How you doing?
Good. How are you doing? Jesse Stroud?
Wow, you're looking good there, Mr. Stroud. You didn't show up for court just like that on Zoom, did you?
Yes, sir.
Wow. Somebody's showing some respect. That's kind of cool to see if you're me. You know what I mean?
Yeah, I understand.
All right. Did you learn anything here?
Yes, sir.
I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes, sir.
All right. Since you were in court and I sentenced you on the order of probation on October 22, 25, have you been arrested for any reason?
No, sir.
Any new charges pending against you?
No, sir.
And you haven't had any police contact?
No, sir.
Well, I wish you well, Mr. Stroud. I'm going to go ahead and dismiss the case on motion of the prosecutor. You were compliant. Good luck to you. Stay
Thank
clean
you.
now, will you please? Stay for yourself. Okay?
Yes, sir.
Good luck.
Thank you.
Marquita Nicole Collins, 246206. Good morning, ma'am. Your name, please? You're charged with driving on a suspended. You have the right to an attorney. If you want one, I will give you one. Do you understand that?
Yes.
Would you like an attorney to represent you? Okay, we're going to give it.
I thought we already explained that I have my license and my insurance, so I thought we had dropped it.
This is just to arrange. We just scheduled this for an arraignment and a pretrial today. You haven't been in front of me on this yet.
Huh?
You have not appeared in front of me on this case yet. Did you?
I believe I did.
No.
Probably.
Was it another one?
Okay, it was another one. She said yes.
Okay. All right. I'm going to go ahead and give you a defense lawyer. So you can go out in the hall and we'll set you up, okay? Good luck. Amy, somewhere down there, you should have a file with Mr. Hill as the lawyer.
That's this one right here.
Okay, perfect.
We don't have one.
Is Mr. Hill here and his client?
Yes.
That's, pardon?
Yes, they're both out here, Judge.
Okay, bring
want me to
them
bring
in,
them in?
please. This is people against Todd Dwayne Johnson. Todd Dwayne Johnson, 2627130333. Your name?
Good morning, Your Honor. Alex Hill on behalf of Mr. Johnson, P76961. Mr. Johnson, will you state your name?
You have to start your video, Mr. Johnson.
Stream, okay.
Your name?
Todd Dwayne Johnson.
So I got a stipulation from your lawyer in an order to adjourn, a proposed order to adjourn that the prosecutor agreed to. But I did not do the arraignment on this case, and there are some bond conditions that I need to add, okay? There was a visiting judge in here at that time. So counsel, what would you like to say? I understand that the visiting judge gave him a personal bond of $1,000. I have no issue with that. But I do have an issue with, I need to address some bond conditions here besides no alcohol or drugs. So
Absolutely, Your Honor.
can you tell me when his prior was?
It was at least a few years ago. Mr. Johnson, what year was your prior alcohol?
2020.
2019 or 2020?
It was 2020. Huh. What was the alleged, this is a alcohol case that I'm looking for the breathalyzer blood result.
I don't know the older case, Your Honor, but I know the present case, the alcohol allegation is relatively low. I haven't reviewed all the discovery, but my understanding is it's around the 0.1 level. But he does obviously understand the concern. He wants to show the court he's compliant with a no alcohol condition.
Over a 2-1 though.
For the first one or this one?
This one.
Okay.
He had a 227 on the first test and a 214 on the second.
That is a concerningly high level, Your Honor. We're not opposed to a testing condition. I don't know if Mr. Johnson is travel wise to get testing. If, something like 2 times a month random would satisfy the court, but he would have to go, or if he wants to ask for a SoberLink device where he could blow 2 times a day or at the court's discretion to verify he's not consuming any alcohol. Mr. Johnson, do you have a preference between random testing set by the judge or a SoberLink device so that you can not need to go and report for testing on your days?
He's
Oh,
not
yeah,
going
I
to
mean,
get to, he's
yeah,
not going
random
to get to, he's not going to get to decide that, okay?
I understand. Okay, Your Honor. We leave it to the court's discretion, but he is ready, willing, and able to show the court that he's going to refrain from alcohol as this case proceeds.
I'm going to give you a number. Are you at home, Mr. Johnson?
No, I'm actually in my work van like right now.
Okay, you have a pen?
I can take it.
Yes, I do. Yeah. Yes, I do. Hang on. Let me grab my notebook here like real quick. Okay, I'm ready.
So, counsel, why don't you write this down too? I'm going to give him $1,000 personal bond. You cannot have any contact with prosecution witnesses except through your lawyer. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to attend AANA at least twice per week. Counsel, if you don't have any AA forms, we will send them to you and you can get them to your client, but you're to immediately start going at least twice per week. And that has to be in person. Also, you must obtain a SoberLink device by the end of today. You must obtain a SoberLink device by the end of today. You're going to have him call this number in the probation department, 734-671-0201, extension 245. They're going to explain to him where he has to go to get that and what kind of cost there is. Heather, I want to know the pretrial date that you've given Mr. Johnson, if you, Mr. Hill, rather, if you haven't, if you've done that already.
July 14th at 9:30.
July 14th at 9:30 will be the pretrial date. So you understand everything I said, Mr. Johnson, correct?
Yeah, yes, I do. The only thing is, as far as the device or what you're talking about, like I'm kind of ignorant to that. I don't even know what that is.
I'll talk to you, sir. It's a
SoberLink device,
Okay.
it's a portable breath machine, and you're going to have to blow into it 5 times per day. Don't
Okay.
miss a test, okay? Or the bond is subject to being forfeited. You understand?
Okay, and only reason I'm asking is because is that something I do it's something I can take with me. So I can take it from my personal vehicle to my work van to personal vehicle. It's something I just carry with me all the time.
Correct.
Okay. All right. Okay. Thank you.
So counsel, call the probation department and set that up and make sure you get them an AA form. If you need any assistance, you call.
Absolutely, Your Honor. We appreciate that.
Okay, and it's PM's here today, right, Heather?
As far as I know, yes.
If not, you're going to call this extension. What's yours again, Heather? It's
228.
228. Okay?
Thank you, Your Honor. We look forward to moving the case forward on the 14th.
Thank you. Good luck, Mr. Johnson.
Thank you very much.
Salvatore Gabriel DiMatteo, 26B839-108.
Johnson.
Right up to this podium, sir. That's all right. Your name? How you doing today? You're charged with animal vicious act. That's a misdemeanor. You also have 2 civil infractions, no dog license and dog roaming at large. You have the right to a lawyer. If you want one, I will provide you with one at public expense. Would you like an attorney? Yes. Okay, you can go right out in the hallway. We'll set you up with a defense lawyer, and then either way, you're coming back in front of me today, okay? People against Shannon Sherelle Phillips, 26B150905A and B. Good morning, ma'am. Your name? Okay. Do you have your discovery yet, ma'am? Everything you need?
No, I just received it yesterday afternoon at about 12.
So you have it now?
Yeah, but I haven't reviewed.
No, I understand. I'm just, that's what my question was. Do you have everything that you need?
Yes, I just got the email. I didn't really go through it. I think like 4 attachments. But yeah, I did receive discovery.
Okay, so we'll go ahead and you can review all that. I'll give you a 2-week adjournment. We'll set this for July. What are we doing? The 15th, Heather?
Yes, July 15th at 10 o'clock.
And you still don't want an attorney to represent you?
No, sir.
Okay. July 15th at 10. If you change your mind, can you afford your own lawyer? I'm just curious.
Yeah.
Okay.
Mhm.
Okay. Right. So if you can afford your own and you decide to hire one, bring him or her with you. If you decide to represent yourself, that's fine. I'm still going to suggest you get a lawyer, but you do what you want. You have the right to represent yourself. Okay?
Yeah.
Go down the hall. They'll give you a paper notice. Good luck. You're welcome. Fleming, D'Artagnan, Kenyatta, Fleming, 26B, 14998, 1A and B. How you doing, Mr. Fleming? Good. Your name? Okay, just keep your voice up nice and loud for me, okay? All right, you have a charge of trespassing and consuming recreational marijuana in public. That's a civil infraction, the recreational consumption of marijuana in public. The trespass is a misdemeanor. You have the right to a lawyer. I'll be happy to provide you with one if you would like one at public expense. Would you like an attorney?
Yes.
Okay. I'll get you a lawyer. Just remember, you have to enunciate everything and keep your voice up when you come on back, okay? So we're going to set you up with an attorney as well. And after you speak with your lawyer, you come on back in with your lawyer, okay? Good luck. Is Mr. Courts ready on his sentencings?
He was working with someone's fine.
Mr. Courts, are you ready?
Yes, I am.
Bring your client in, please. Morning to you. People against Jacob Michael Douglas, 24B1470488.
Good morning.
Hang on one second. I also have 24B1470755B and 24B1470448B. All right. Good morning.
Good morning, Judge Attorney Thomas Courts. Here on behalf of the defendant, sir, can you say your name for the record, please?
Morning, Jacob Douglas.
All right. So let me just recap here. He pled guilty to operating while impaired due to the consumption of drugs. He also pled guilty to failure to report a property damage accident. The original charge of operating while intoxicated due to the consumption of drugs or operating while with the presence of drugs was dismissed, and as was the leave the scene of a property damage accident. He also has an outstanding civil infraction in front of him that he did not pay dating back to 2023. I mean, it was the same date. They've got a different case number. It's just 7075B instead of, I'm not sure why they were not consecutive here, but at any rate. So I referred him for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have, Judge, while it was accurate at the time, there are two updates I'd like to share with the board.
Okay.
His employment status has changed. Instead of working at Arby's,
1 second. Okay, instead of working at Arby's part-time, he's what?
he's now working, doing fruit. There's gutters. He's not doing gutters at Gene's Construction.
Okay, I'll modify the report in that aspect.
And then, Judge, there's also, his 2-year-old child. The mother has lost her job, and so now he is providing, assistance and help with.
Okay,
Besides that, Judge, we believe the report to be, fully accurate.
all right. Anything you would like to say on his behalf?
Okay, Judge, thank you. The case is from 2023. That's not the behavior, but it is to say, Judge, that there's a slightly different person that stands in front of you. He came to court today. He's voluntarily trying to handle his legal matters. He's working, he's employed. He's got a child back in 2023. He didn't have a child. My client, this is a drug-related problem, and he's telling me that if he were to test him today, he'll test positive, Judge, which really changes the whole dynamic of
He were test positive?
Oh, I'm sorry about that, Judge. He's positive that he would test clean.
I don't usually expect defendants to come up here and acknowledge that they've violated a bond condition, so I'm glad to hear that at least, but go ahead.
Thank you. So he's, so I would ask, Judge, that he be put on probation because the underlying drug problem wouldn't be treated.
What happened with his assault with intent to do great bodily harm, less than murder probation violation out of the Third Circuit Court? Does he still have that outstanding?
He has that, Judge, but we are handling that. I am going to take on the case of Taylor where that violation came out of. And we are going to go in front of Judge Casca, preferably this week, and turn him in on a warrant. He wanted to come and take care of this, but we're going to take care of that warrant and tell the judge we're fighting that case, Judge.
Okay, why isn't he showing up on that? The date of that warrant was only June the 18th, but nonetheless, he received notice. Why didn't he show up?
Judge, I don't have a good explanation for that, but we can go there immediately. I'm going to circuit court right after this, Judge. If you'd like, I can take him with me and turn him in for his warrant.
Okay, go ahead.
Thank you. And that is all I'd like to say on my client's behalf at this time.
What are you doing? What are you doing? I don't know how many chances you think you're going to be given. I get the fact this is a first drug or drunk drive. I'm not looking at things in an isolated fashion. You got a big problem. Well, I'd like to believe you've changed, but it's hard for me to believe you've changed when you had assault with a dangerous weapon in 22. Granted, this is a 23 case. Then you were convicted of assault with intent to do great bodily harm and felonious assault. And another count of felonious assault in the Third Circuit. Then you had an aggravated assault out of the Third Circuit. So they must have pled that down from an initial felony. Then you were arraigned on a charge. You have a case out of the 23rd District Court for malicious destruction of property. Now, that's just an arraignment. Maybe you weren't even there. It might not have been, it might have been somebody else. I don't know. Then you were arraigned on a charge of domestic violence out of the 23rd District Court on a charge of domestic violence, same date from the MDOP. Also arraigned on a charge of assault and battery out of the 23rd. Now, again, maybe you're innocent in all those. Maybe you were out of the country and somebody used your name. I have no clue. But you're not doing too good. You leave the scene of an accident here.
I understand. A lot of that stuff happened before I had a daughter. That was 2023. My daughter was born 2024.
Didn't happen before 23. The only thing that happened before 22 happened before you had your daughter born.
Yeah.
And it doesn't even sound like you spent a lot of time because, correct me if I'm wrong, this claims paternity to a 2-year-old daughter, but reports not paying any child support or being involved in the child's life. That's what you told probation. Is that true or is that a lie?
That's not true.
You told them you weren't involved in your child's life?
Well, at the time, I was working at Arby's and I had got a good job.
Hang on a second. Let's slow down. You just started on this case on April the 20th, right?
Yes, sir.
You reported at the time of the screening, which was on June the 17th, which was only 2 weeks ago, right?
Yes, sir.
You reported all of this to the probation department, right? And now you're saying, well, my life changed when I had my daughter, even though you had the daughter in 24 and all these other events have happened in 25 and 26. And now you're making it sound like you changed in the last 2 weeks.
Well, a lot of those things, you know, the crime was committed in the 10 years. I wasn't convicted until
I don't want to hear anything about the charges. All I know is the probation department is recommending jail, and I don't blame them. And I'm only talking to you because I'm trying to figure out how I can rationalize in my brain not sending you to jail.
Yes, sir.
And could I speak just that quickly, Judge?
Sure.
As this case relates, just as this focus case is about drugs, I would argue that this case would be better treated with probation. And those other instances, Judge, you're definitely, of course, right to take note of them. But he's going to have to answer to Judge Casca, who specifically handled that case and that violation. And deal with the judges and Taylor for the underlying facts, Judge. So I would just ask for the mercy on this case to let him have probation. And if the facts of those other cases, when they're fully fleshed out, warrant jail, I'm sure the circuit court will issue that.
Look at all these substances you had in your system. You had no business driving. No wonder you drove into the utility pole. It's a good thing you didn't hurt yourself or somebody else. Then you left the scene. Then you ignored the court. You didn't show up. You're lucky. You are really lucky. You know why you're lucky? I'm not going to take into account any of these new charges where there have not been convictions. That's not appropriate for a judge to do. I'm not going to do it. That's not appropriate. That's not the way our system works. Or should work anyway. But you are going to be on a short leash with me. And I am going to trust, Mr. Quartz, that you are going to take him down. You said you were taking him down today?
Yeah, well, as long as he has no objection, you can ride with me and I'll take you down there right now.
Are you going down there? Because I'm going to order you to go.
Yes, sir.
And if you don't go, you're going to serve 93 days. And you tell Judge Casca I said that.
Yes.
All I know is I don't like the way your life is going so far for you, not for me. But if you end up in poverty, it's no skin off my neck. You don't have a diploma. You don't have a GED. You're making $250 per week. Maybe this job's going to pay you more. You fathered a child. You had nothing to do with the child. That's bad. I can't stand that. I think any man that impregnates a woman, if you don't take responsibility for that child emotionally, financially, well, then you got a lot of answers to give yourself when you look in the mirror the next time. But I'm not going to penalize you for being a bad father. I'm not a social worker. I'm not a priest. You are on such a short leash with me, you have no idea. On the drug driving, the operating while impaired due to the consumption of drugs. This is the sentence of the court. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. By the way, do I have proof that he attended AA? NA? Did you show it to your lawyer?
I did not, but I do have.
Show it to them. I expect to see that you've gone twice per week since June the 17th. If there aren't at least 4 on there, I hope you brought your toothbrush.
Judge, just for full disclosure to the court, so far there's only one listed, but we'll get them there, Judge.
Okay? You're not taking it seriously then. And I don't want to hear any more. She talks cheap to me. Had you gone to AANA, I was not going to send you to jail. Now you lose. Now you lose. I don't want to hear another word. I don't want to hear another word. I'm not going to listen to you. Tells me you don't take courts very seriously.
Pointed today to go to a meeting. I was actually.
Too late. Too late. Too late. 24 months probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're to submit to chemical testing, PBTs, and ETG tests. That'll be weekly for 3 months. If you are clean, it will then be bi-weekly for 2. If you are clean, it will then be monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to obtain and maintain employment and provide proof. You're to obtain a high school diploma or a GED. You're to attend AANA twice a week until you are in an outpatient substance abuse treatment program. Once you get in outpatient substance abuse treatment, you no longer have to attend AANA. You're also to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. Defendant to surrender to the Wayne County Circuit Court for probation violation hearing on warrant entered on June 1826 within 2 business days of his release from jail. Now expect proof of that. You are to serve 12 days jail credit 1. You're going to serve 6 now, and you're going to serve 5 more days on the court work program pursuant to the probation order. There's a $35 a day charge for that for a total of $175. You're to pay fines of $300, costs $250, $75 victim's rights fee, $50 justice assessment, that's $675, screening fee $60 for $735, probation fees are $40 for $1215 plus your court work program fees. The total's $1390. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. On the failure to report a property damage accident, I'm simply going to go 100 fines, 100 costs, 75 victims' right, $50 justice assessment, 3 1/4, 5 days court work program days concurrent with that I imposed on 25B147048A. I will simply go out of my way and give you credit for time served on the no proof of insurance. Defendant given credit for time served on the no proof of insurance, Heather, but he still must pay the clearance fee. So you're still going to have to pay your $45 clearance fee. Now, he doesn't have any money today, does he?
I don't believe.
You don't have any money.
I have a few dollars on my channel. And like I said, I've been working endless hours.
Okay, good. Do you have enough to pay the failure to report a property damage accident? That's 3 1/4.
No.
How much do you have?
I'm pretty sure I have like $100 on my channel.
So you're sure you can pay 100 today or not? Just tell me the truth. I'm not going to penalize you anymore.
I think it's like $90 a month.
You pay $90 now on that. Then you're going to pay $30 per week on that case beginning on July the 31st. If you don't have the money, you call the court. We'll go on Zoom hour before the due date at 8:30, or you can come in and talk to me on it before the due date at 8:30. Then you're going to pay on the other case, the operating while impaired due to the consumption of drugs. You have a bond of $5,000, 10%. I'm pretty sure we can apply that with the 10% because he's not been discharged from obligations with the court. So you're going to pay $450 now on that and $30 weekly after fines costs paid on 7048B. You are in custody for the next 6 days. I'm not going to change my mind. Maybe next time you'll understand you're going to comply with my orders. If you don't, you're going to end up going back. It's time for you to grow up. You're 22. Get away from this criminal activity. Start acting like an adult. Good luck. Thanks, Mr. Forth.
Thank you, Judge.
Jaroslow Siamonic, 265-415-32. Good morning.
Middleton.
I hope I didn't scare you after that one. Your name?
Charles Lexington.
All right. Okay, you're going to plead impeding, right?
Yes.
Responsible or not responsible? Please accepted, speeds dismissed, 170 is your total. You can go down the hall and take care of that and you're all set. Good luck.
Okay.
Stephen Lee Miracle Jr., 25B148937. Morning, sir. Your name?
Stephen Leader.
All right. You are charged with larceny. You have the right to an attorney. I'd be happy to provide you with one at public expense if you would like.
Please.
Okay, we'll give you a lawyer. You'll go out in the hallway and we will set you up with an attorney, okay?
Thank you, Your Honor.
You're welcome. Good morning.
Morning, Judge.
What are you here on?
Orator's Johnson, your sentencing, I'm ready with that.
Perfect.
This one.
Orator extension. Oratory is Brandon Johnson, 26B150198A and B and C.
GOP 8237, we only have Mr. Johnson, station.
Charles Johnson.
He's another one that gets himself in a lot of trouble, huh? I mean, these are suspend, I guess, just going back to 16, but what's he doing with opiates that weren't prescribed? I mean, he pled guilty. I'm not going to take it under 7411. He's got another case where he had one. I'm prohibited from doing that. He's got another drug conviction. I don't know if we covered that, but I'm not going to take that under 7411. Just gonna,
I've never had any.
2014. I didn't say pills. I don't know what it was.
Yeah, it was marijuana.
2014.
I can't do it. So if you want to go talk to the prosecutor again, you can. If you want to tell me, Judge, we'll just accept that as a plea as charged. That's fine. I will still honor the other charge, the resist and obstruct under 771.1 that he pled to. And that was back on, what day did I take that plea? What day did I take that plea? I wasn't very good with noting this, Heather. Heather, it looks like on June 17th. So I took that plea.
Yes, Judge, it was.
June 17th. And you can just tell me what he wants to do.
He wants to move forward with the sentencing.
So you acknowledge and understand that this conviction for possession of a controlled substance will go on your record, that I'm not going to take it under section 771. I'm sorry, section 7411. The conviction will immediately enter. It will be on your record. And it's not going under that statute, and I will sentence you on that case. Do you agree to that?
Yes.
And you acknowledge I need not take a plea again, counsel?
Yes, Judge.
All right, I'm just give me a second to make a note. Case not taken per 7411. Please make a note of that, Heather, because defendant had prior drug charge in 2014, prior drug conviction in 2014. So I'm just going to go ahead and sentence you anew on that. And with that, counsel, we have a plea as charged, possession of a controlled substance. We have a plea to resist, hinder, and obstruct an officer. And that's going to be taken under section 771.1. And then there was an expired plate charge that the prosecutor agreed to dismiss file C. So I'm only going to deal with files A and B. Have you had a chance to review the report with them? And are there any material additions, corrections, or deletions?
We have, Judge, there are no additions, deletions, or correction.
Anything that you would like to say on his behalf?
Yes, Your Honor, as the report said, he is employed, he has a couple of children. I would ask of the court, if the court is going to order any days on that court work program, if the court would take into consideration that Mr. Johnson does work full time. He does like to spend time with his kids on the weekends, so I would just ask if the court would take that into consideration. Other than that, Your Honor, we would ask if the court would adopt probation recommendation.
Anything that you would like to say?
I apologize for the time that I took for the work. I do have a 1-year-old and a 4-year-old that's autistic, which I take care of because the mother is not working at the time. I don't do any drugs. Everything I have done is marijuana. I have a marijuana card. The pills that I did have in the card, that was in my possession, but I don't take any type of restricted pills or I don't drink alcohol or anything like that. And I do agree with what you said, the other cases about fine, so I just want to let you know.
Well, that's nice to know, but why would you have possession of something if you don't use it? Why would you have possession of opiates that were not prescribed to you that you reported you obtained from another individual? Why would somebody acquire something? You have to take your hat off, please, sir. Why would somebody acquire something and have it in their possession if you're not going to use it?
At the time, Your Honor, there was the person that was fixing on the car that wasn't mine. It was a new car. When I was dropping the car off, I was taking everything out of the car and I did put them in my pocket. The person who prescribed me had a prescription for them. And at the time, I did have an eruption of eardrum things. They wouldn't prescribe me anything.
So you were just going to self-diagnose?
Yeah, they only gave me some antibiotic drops. So that was in the lot. I mean, never got a chance to take. I didn't even know exactly what they were, so I didn't have any intention on like had a look or whatnot. But I haven't took any type of other medication in years.
So you drive out to Ann Arbor every day?
Yes, sir. I work for a nonprofit in Ann Arbor. Recently, I've been here about 10, 12 years, 10 to 11 years. Drive about 40 minutes from Trenton to Ann Arbor.
And are you primarily, you still reside, correct me if I'm wrong, with the mother of your children?
Yes, we've been together about 15 years.
Okay, so does she work?
She was working for.
I didn't ask you.
Oh, no, not right now. She's not working. We have a 1-year-old that she's taking care of full time, so she's not working.
You gonna straighten out your life here?
I thought I did. I haven't been in trouble in 2 years, so I didn't been. I don't think.
Then you tried to evade the police, right?
No, actually,
You didn't try to evade the police? You told me at the time of the, hang on. I asked you what the basis for the resist and obstruct was. You said you didn't stop when you knew they were trying to pull you over. Do you want me to go listen to the tape?
No, you're not there.
Well, is that what happened or is that not what happened? I'm not trying to trick you. I just don't want you to come up here sounding like a choir boy when You tried to evade the police. They could have charged you and should have charged you with fleeing and eluding. You got it? Can we agree to that? I don't want him just to tell me he agrees if he doesn't agree. I'm not trying to trick anybody here. That's not what my purpose is. I just want to have a discussion with you and try to figure out why I think that you're going to do better. And I can't say I see a lot of reasons on that right now. All right, counsel, what else? Anything else that you want to say? I mean, if I'm missing something, feel free to tell me, Judge. I don't think you're looking at this right.
So Your Honor, that night, it was dark outside. Mr. Johnson did see police. I don't think it was an intentional invasion at first. It was he thought they were behind somebody else, but it was dark and you got all these police lights behind you. So once he realized it, which was a mile or so later, he did pull over, but it wasn't an initial, I'm gonna run from the police.
Well, at some point he had that mindset. Is that true or false? If it's false, then I shouldn't have never have taken the plea. Right?
It was a situation, again, Judge, it was dark. You got all these.
I know, but I'm just asking you, if he wants to withdraw his plea because he doesn't think he did anything wrong, I thought at the time he told me he drove when the police were following him, and I'm not trying to, listen, I'll let you withdraw your plea right now if I made a mistake by accepting a plea that I shouldn't have accepted, I'm going to let you withdraw your plea. Yeah, I thought you told me at the time of the plea because I couldn't understand the basis for the resist and obstruct because you didn't provide me any in the beginning, was that you knew the police were coming after you and you continued to drive. Did you tell me that or not? I'm just asking you, did you tell me that or not? I know how I do things, and I know I don't take pleas when there's not a factual basis. I know I don't do that. If I do, I've made a mistake. And if I've made a mistake, I'm going to rectify that mistake and allow you to withdraw your plea right now. And I'm serious about that. In fact, I'll let you go talk to him about that. I'll be glad to do that because I don't want to take a plea from anybody to anything that's a criminal charge of any kind if they didn't commit the act. And I thought that's what he told me. If I misunderstood, it's my fault. I'll accept responsibility. I'll let him withdraw his plea. We can go back to square one and you can go back and negotiate with the prosecutor. But I thought I heard him say that. If he didn't say that, then that's my fault.
Well, Judge, I think what he said was he knew they were behind him and he should have pulled over. I guess even just to be sure that they were behind him. Let's figure out.
I don't want you to say anything right now without talking to your lawyer. Would you talk to your lawyer first and make sure that we think that you're guilty of that offense? Because if I misunderstood what he said to me, I do not want to go forward with the sentencing on the RNO. And in fact, if he's not guilty of that, maybe the prosecutor can reevaluate and decide she wants to dismiss that case. I don't know. But I'm not going to take pleas and then have somebody come in at sentence and tell me something different than what I thought they said. So if he said something that I misunderstood, my fault, I take responsibility, and you guys can go back and talk to the prosecutor. But I think you should talk to your lawyer before you say another thing, okay? And again, so you got two charges, and if he doesn't feel like he's guilty of the RNO, I don't want to wait. Okay? Thanks. Raymond Lawrence, winner the second, 26B151596.
Good morning, Your Honor. Deanne Fitzgerald, 82378 on behalf of Mr. Winter. Say your thing.
Raymond Lawrence, 147.
Good morning, sir. This charge here is a malicious destruction of property, and you're requesting a bench trial. Is that right?
Correct.
You have the constitutional right to a jury trial, sir. If jury trial, 6 people would be impaneled. All 6 would have to agree that you are guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand?
Yes, sir.
You wish to waive your right to a jury trial?
Yes.
Anybody in the world force you to do that?
No.
I'll accept the waiver. We'll set it for bench. What do you have for me, Heather?
Judge, do you want to do this bench trial on one of our Wednesdays or one of our Thursday Brownstown days? Or do we need to do it when Miss Patillo's here?
Miss Patillo's here on Thursdays?
I don't know if she has any Thursdays with us.
No, I don't. I have some Wednesdays, no Thursdays and 33rd.
Can I get you to come in on a Thursday or do you not have?
It depends on the date.
How about how do I look on the 16th, Heather?
Let me, we can,
Or is that,
I'm also on another court.
how about on the 30th?
we don't have Brownstown on the 30th.
I don't have Brownstown on the 30th?
No, we have them on the 16th.
I thought I had them every 2
Sorry,
weeks.
I don't have them on our docket for the 30th.
And with one Thursday a month, you have Brown.
I see. How about, what do I have on the first Thursday in August? Can I do it then or not?
We actually don't have them until August 20th.
I'm sorry, Heather, I didn't hear you.
We don't have them till August 20th in August.
I can do August 20th. Are you available?
Yeah, actually, I am.
I'm here that day, right?
Yes, you are, Judge.
I'll do August the 20th. August the 20th at what time, Heather?
Since it's a bench, do you want to do it at 11?
Sure. 11 a.m. on August the 20th, okay? So, sir, you'll go down the hall, we'll give your notice and see you on August the 20th. Any questions? Anything else on that, Ms. Patillo?
No, you're on the date.
Do you want these files back on the other one, or you want to just go talk to them? Thank you. Okay, Lillian J. Star Trotter, 26B150733A and B. Good morning, counsel. How are you?
I'm doing well, Judge. Kenneth Camilleri on behalf of Lillian Trotter, Your Honor, who's sitting to my right.
Okay, I'm getting a little, can you get that device a little closer to you? Ma'am, tell me your name, please.
William Trotter.
All right, just keep your voices up nice and loud if you would. I don't know, it's not coming through as strong as it usually does. So I have a plea agreement here that says that the defendant is going to plead guilty to the added count, lesser included offense, I should say, of operating while visibly impaired. The super drunk or high BAC charge would be dismissed. Also, that the defendant is going to plead responsible on count 2 to an amended charge of distracted driving, and the prosecutor then is going to move to dismiss the open intox. Is that right?
That is a correct statement, Your Honor.
Ma'am, is that what you would like to do?
Yes, Judge.
If you plead guilty to operating while impaired, here are the possible penalties. Up to $300 fines, 93 days jail, 360 hours community service, court costs, or all those, 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. If you plead to distracted driving, that's a 0-point civil infraction. You understand that? It won't get reported. You understand that?
Yes, Judge.
And then I'm going to dismiss the open intox and the super drunk. You understand that?
Yes, Judge.
I want you to understand that you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. At a trial, you have the constitutional right to a trial by a jury. You could subpoena your own witnesses. You could testify or remain silent. If you remain silent, the fact finder would be instructed that they could not hold that silence against you. If you plead guilty, you're giving up all those rights. You're giving up the presumption of innocence. You're waiving the requirement that the people prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, Judge.
You fully understand everything.
Yes, Judge.
To the charge operating while visibly impaired, ma'am, how do you plead?
Guilty.
Were you operating a motor vehicle on West Jefferson near Campo in Brownstown, May 2nd of 26 at 2:30 in the morning?
Yes, Judge.
Prior to that, did you drink alcohol? And if so, what did you drink and how much? Nice and loud for me.
Yes, Judge. I had about 8 bush lights.
And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes, Judge.
In what way? Why were you pulled over by the police?
I hit a curb and wrecked my truck.
I'm sorry.
She stated she hit a curb, Your Honor.
You hit a curb when you were driving?
Correct, Judge.
Is that right, ma'am?
Yes, Judge.
Was there an accident then?
There was a one-car accident, her car, Judge.
What did you drive into then, ma'am?
The median.
A what?
The,
Median in the road, Judge, there's a new median on West
Okay.
Jefferson.
All right, so you drove into the median and then the police came to the scene?
yes,
And were you administered a breathalyzer test at the police station or was this a blood draw?
Blood draw, Judge.
Blood?
Yes, Judge.
And do you stipulate that the reading of 0.205 was an accurate reading for purposes of the plea?
The defense would stipulate, Judge.
I'm sorry, I don't know why I'm having a hard time.
Yes, Judge.
Are you on probation or parole right now, Ms. Trotter?
no,
Anybody force you to plead guilty?
no,
Into the charge of distracted driving, you plead responsible or not responsible?
responsible,
Plea is accepted to distracted. Plea is accepted. I find it to be an accurate plea, operating while impaired. I'm going to go ahead and dismiss the super drunk charge on motion of the prosecutor, as well as the open intoxicants on motion of the prosecutor. I'm going to refer you for a screening and assessment. They're only requesting 168. I give 2 1/4 on the blood draw, but if that's the extent of their bill, that's what they're going to get. We're going to have a screening and assessment. You're going to have to come up here, fill out a questionnaire, and be interviewed. Has she been going to AA, and did she show you proof of that?
I have seen the sheets, Judge. Yes, she's attending as required under her bond conditions.
All right. I didn't realize the breathalyzer, I don't think, was this high. It's pretty high. I'll still keep it once a week, but I need full compliance. You understand that?
yes, Judge.
All right, so let's get a sentencing date for you, Mr. Camilleri. What do you have for me, Heather?
July 15th at 8:30.
Is that good with you?
Yes,
Yes, Judge.
All right, we'll do July 15th at 8:30. I'm deferring the sentencing on the distracted. I'll sentence you at that time, but I do need you to come up to the court and meet with probation and fill out your questionnaire and be interviewed. Okay, ma'am?
yes, sir.
All right. You seem very respectful. This is a lot of alcohol. We're going to make sure you don't have a drinking problem, okay? And take care of that, all right?
Yes, sir.
Good luck to you. Thanks, Mr. Camilleri. Have a good day.
Have a good weekend, Judge.
You too. Thank you. Angela Ardith Rice Day, 26B838848, and B and C. You know where I got this one. Your name? Ma'am, you're charged with Animal Vicious Act, and you also have 2 civil infractions, dog at large and no license on the dog. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney? All right, I'm going to provide you with an attorney, and you can go out in the hall, and we'll set you up, and we'll go from there. Okay, thank you. Do I have Scott, Terrell Dwight Scott, 26W842-496, 26W842-665.
Good morning, Your Honor. Patrick Crawford representing Mr. Scott. Mr. Scott, please state your name for the record.
Terrell Dwight Scott.
This is, okay, so what are we doing here? This says he's going to plead guilty to stalking on file 2496. That's offense date June 25th. They're going to dismiss, if he pleads to that, the trespassing charge on file 26W842-665. That's a different offense date. That was April 26th. But it also says here, defendant has 2 new trespassing cases scheduled for July 13. Somebody wrote down, let us know if you want us to pull them. Who, is that your handwriting, Heather?
Oh, it was mine, and it was directed to Mr. Crawford, or the attorney.
Oh, I see. So I'm just going to go ahead with these 2 now, and then we'll go from there. If you plead guilty to stalking, they've only charged you under local ordinance. It is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that, sir?
Yes, sir.
If you plead guilty to that, the prosecutor is going to ask me to dismiss, and I will dismiss 26W842-665, that trespassing charge. I will also tell you that the possible penalties on this are up to $500 fines, 90 days jail, court costs, or all of those. Do you understand that, sir?
Yes, sir.
Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial. At a trial, you have the right to remain silent. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in your own witnesses. If you choose not to testify, that silence would not be held against you at a trial. If you plead guilty, you're waiving your right to a trial of any kind. You're also waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, sir.
All right. Do you have any questions before I ask how you plead?
Guilty.
Hang on a second. You act like you're bored.
No, sir.
You're bored. Is this what you want to do?
Yes, I'll take it. Yes, sir.
Don't act like you're doing anybody any favors. This is important. If you don't
Yes,
want
sir.
to plead guilty, just tell me. We'll stop the process now. If you do, tell me that. Do you want to plead guilty or not?
I plead
To the charge of stalking, how do you plead?
guilty.
Were you at or near 25338 Oxford Street in Woodhaven, June 25 at 26 at 3:22 in the morning?
Yes.
And were you at the property of an individual by the name of Christine Weisend?
Yes.
Okay. What did you do that makes you guilty of the offense of stalking?
Knocked on the door.
Crawford, did he do anything else besides knock on the door at 3:00 in the morning? He had to, or they shouldn't have charged stalking.
Your Honor, my client showed up at the residence in question after being warned and trespassed several times in the past, and he defiantly showed up at his home and knocked on the doors throughout the night with the knowledge that he was not welcome there by the alleged victim.
The alleged victim was not alleged victim or victim Christine Weisend, right?
That is true.
Yes. Okay. Had Christine Weisend advised you on multiple occasions not to go back to her residence?
I believe you have, yes. I believe so, yes, sir.
Your Honor, to assist my client, I might remind him that the police also told him that he could not return to this property several times in the past. Isn't that
Mr.
true,
Scott,
sir?
if you don't want to plead guilty, we'll set it for trial. I'm not gonna ask you a bunch of questions here. You're gonna tell me yes or no. Did she tell you or did she not tell you on multiple occasions not to go back to her residence?
Yes.
On how many occasions did she tell you not to go back to her residence?
I'm not sure. A few times.
What's a few mean? 10?
About 3.
And did the police also tell you not to go back to her residence?
Yes.
Had you previously dated her? What was the relationship here?
Yes.
So she broke off the relationship. Is that fair?
Can you repeat that? I can't hear you.
Did she break off the relationship?
I think the evictions broke off the relationship, not so much as she or I did.
She tell you that she did not want you to go back to the residence?
Not due to the relationship issues. It was more to the fact of, I guess, me being evicted from her property or something like that.
Your Honor, if I could assist the court, the alleged victim filed for eviction against my client.
Is that true?
Yes, sir.
So she filed, you guys lived together for a while, right?
Yes.
The property was in her name, correct?
As far as what I've seen on the paper, I guess so.
And then she filed a notice to evict you, a 30-day notice to evict you from the property. Is that true?
Yes, sir.
Were you evicted from the property by a judge of this court?
Yes, sir.
Is that in front of me or Judge Hessen?
You, I believe.
Okay. And after that occurred, did you continue to go back and contact her or appear at her residence?
Yes.
Did she tell you not to come back on several occasions?
Yes.
Did the police tell you not to come back on several occasions?
Yes.
And did you then knock at her door at 3:00 in the morning after you'd been warned by her repeatedly not to go back, and after the police had told you on June 25th, specifically at 3:22 in the morning?
Yes.
Probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Is it fair to say that she told you she didn't want you to go back because she wanted to and evict you because she wanted to not have a relationship with you anymore?
Those wasn't the exact words, but I guess it's not fair that I still went.
What's the exact words?
I can't hear you, sir.
What were the exact words?
Um,
I'm feeling like a dentist again, Mr. Crawford. What were the exact words? Why did she tell you she wanted to evict you?
I never really got, well, as far as what the paper says, it said that I was a nuisance to her pregnancy. A nuisance to her pregnancy. I was, I guess you want to say sexually harassing her verbally.
Okay. Why'd you make me sit here and ask you questions for 7 minutes? Please, are you on probation or parole right now?
No, sir.
Anybody forced you to plead guilty?
No, sir.
Something troubled me here, Mr. Crawford. I see the bond I set. I don't usually do that. But I'm going to order a pre-sentence report. I'm accepting that plea. I'm dismissing the trespass. I'm going to order, again, you're not to be released until fitted with a GPS tether. You're not to be within 2 miles of her residence or place of employment. You have to be on that tether. You're not to possess firearms or weapons. You're not to enter or go anywhere near 25338 Oxford in Brookwood. No contact with prosecution witnesses. No contact with the victim. If I find out you're having any contact with her of any kind, whether from there or otherwise, either by text, voicemail, email, letter, contacting her through people or showing up at or near her residence or place of employment, I'm going to give you a maximum here, sir. Do we understand one another?
Yes, sir.
All right. Trespass is dismissed. Bonds continued. We're going to give you an early sentencing date. And I'll look into this. When can I sentence him, Heather?
We could do July 13th at 1:00.
Good enough. Is that good with you, Mr. Crawford?
Oh,
It
you
is,
know
right?
what? Yeah, I would say we have to, is Mr. Crawford here that day or could he Zoom in for the sentencing?
At 1:00, I could Zoom in. I'm not here otherwise. I am
Okay.
on 14th.
Heather, cancel any bond conditions that are not common. Well, I guess they all are, but we're going to take them out on the trespass. We're keeping them on the stalking charge. The trespass is now dismissed. That's what
Okay.
we'll do. July 13th at 1. I wish you well. Good luck. We'll see you then, sir. Stay away from that lady. And if there are more trespass charges, I certainly hope that they are not coming in front of me if they involve this victim especially after an order that I gave. That's all I'll say about it. Are they, Heather? Do you know?
Sorry, Judge, my one earbud went out. What was that?
I just want to know if you know whether or not the new trespassing cases involve him contacting her.
I do not know on that, Judge. I can pull them and look real quick if you'd like me to.
They are your cases and they are scheduled for the 13th. That's the day he's coming back in class.
Why don't you stay right there, Mr. Crawford? You stay right there. Bring those files down here, please.
Okay, you want them down? Okay, I'll pull them right now.
I'll go on to another case in the interim. Salvatore Gabriel D'Amato, 26B83910A, B, and C.
Good morning, Judge and staff. John Bronstein, attorney on behalf of Salvatore Tepe. Please start the appointment, sir. My left, please identify yourself, sir. Salvatore Gabriel Tepe.
All right, good morning. Counsel, I need to know Does he, first of all, does he stand mute and wave formal?
He does.
What kind of a dog is this allegedly?
It's a female German Shepherd that weighs, I believe, approximately 72 pounds.
Does Mr. DiMatteo have a fenced-in yard?
He does, sir, and everything has been taken care of. This is an unfortunate incident that, in my opinion, has been blown up in proportion. There's, any touching that was done, but nonetheless, he's willing to take care of any vet bills, but nonetheless, we, waive a formal rating and stand mute.
Not guilty plea is entered.
We determine where to judge.
Yeah, I'm gonna give him a personal bond of $500. It says dog on dog attack. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Defendant's dog, did you have more than one, sir?
No, sir.
It must be in your house. It must be in your house, in a fenced-in area, or on a leash, accompanied by defendant, and equipped with a muzzle. Do you understand that, sir?
Yes, sir.
So otherwise, you're not taking the dog out of your house or the backyard. Do you understand that?
Yes, sir.
All right, we're gonna give you those.
My eyeglasses are messing with my hearing aids.
No problem. Do you understand everything I said?
The last part kind of cut out on me.
Your dog must be in your house, in a fenced-in yard,
Yes.
or on a leash, accompanied by you and equipped with a muzzle. Do you understand that?
I do, sir.
Okay. And you're not to have any contact with prosecution witnesses. I'll give you a new pretrial date, Mr. Graziani. What do you have for me, Heather?
July 15th at 10 o'clock.
July 15th at 10 a.m. in the morning will be the court date. July 15th at 10 a.m. and you can go down the hall and get your paper notice. And I'm entering pleas of denial on the civil infraction charge.
Okay, thank you so much, Judge.
Thank you.
Thank you, Your Honor.
All right. Peebler, Kyle Stephen Peebler, 26B838059A, B and C. Did you have a lawyer, sir?
He did not. No, yeah.
Okay, your name?
Kyle Stephen Mueller, yeah.
So this says on the bottom, prosecutor moves to dismiss vicious act as defendant voluntarily euthanized the dog. Prosecutor spoke to victim and was advised that defendant paid all related expenses and she does not wish to make a statement. So they're going to go ahead and dismiss. I'm sorry about your dog. I really am. And I'm going to go ahead and dismiss that vicious act. And then, as I understand it, you are going to plead responsible to one count of dog at large with the understanding that the no license and the vicious act dog charge will be dismissed. Is that right?
Yes,
Can you pull that out and tell me what our fines of the dog at large things are, please? All right, to the charge, dog at large, responsible or not responsible?
Responsible. Yeah.
Judge, it's 135.
I thought so. I'll accept the plea. Fines cost of $135. I'm dismissing pursuant to stipulation on motion of the prosecutor, both the no license charge as well as the vicious act charge. Okay.
Yes, sir.
So you can go down the hall, take care of the fines, $135, and you're all set. Best of luck to you, sir. Thank you.
There's a fines on Scott.
All right. Mr. Crawford, can you hear me?
Yes, Your Honor.
I can bring him to you, these to you. These happened after? You better look at these.
I'll come grab the file, Your Honor.
Got Giles, Daniel Curtis Giles.
Yep.
25T646053A. Your name, sir?
Daniel Giles.
All right. You have to pay $200 monthly starting July 1. You're here for time to pay. When can you start paying?
If I could get just a few more months.
Well, I got to get going on this or we're not going to have time to finish it. Where are you working?
I'm not at work yet. I'm still going through physical therapy for my knee.
All right, I got 12 months probation. You started in February, March, April, May, and July. I can start your time I can extend it, allowing you to, you begin on August the 1st, okay?
Okay.
Can you do that?
Yep.
August 1, all right?
All right.
If you need more time, come talk to me, but you're gonna end up having your probation extended if we can't, if you can't pay during the probationary term, all right?
Okay.
Good luck to you.
All right. Thank you.
Zach, Mr. Crawford's looking for those files.
I put them on his desk. He's not
Okay,
there.
he just came in here. Zachary Michael Bowl, 26I 415-321, defendant failed to appear and is responsible as charged by default. Responsible as charged by default. All right, people against Reed, David, Demetrius, Minor Reed, 26I 000-1691 and 1692. Good morning, counsel.
Good morning, Your Honor. May it please the solemn report, Darnell Barton, P 83363, on behalf of Mr. David Minor Reed. Sir, can you state your name and phone for the record?
David Minor Reed.
All right, so for purposes of arraignment, first of all, he has two charges here. Let me just double check. It looks like a super drunk and they alternatively charged OWI. Is that what happened?
That is correct.
And now he stands mute, waits for formal reading on both of those. And then as I understand it now, he's going to plead guilty. I'll just put it on count 2, operating while visibly impaired, with the understanding that the OWI will be dismissed and the super drunk will be dismissed. Is that correct?
That is correct.
Is that what you want to do, Mr. Minor Reed?
Yes, Your Honor.
If you plead guilty to operating while impaired, did he execute an advice of rights form today?
I thought they gave you the other difference. I'll have them fill it.
Here.
I'm sorry, we haven't filled in.
All right,
My apologies.
that's okay. Just have your, who's that? Your associate or your boss?
He is my boss. So if I may, this is Garrett Washington. He's I'm with the Young Lawyers section of the State Bar, and we're doing a program called Journey to Attorney. So we're helping young folks.
Nice.
I want to get to.
Are you a lawyer now?
Not yet.
You took the bar?
Not yet. He just graduated Oakland University. So
Oh, so you got to go to law school.
going to the bar. Yep. We have a high school graduate.
Well, that's fantastic.
2 that are taking the bar in July.
So that's fantastic.
We're hanging in there.
Mr. Minor Reed, just relax. I just am having a conversation here. I hope you didn't take you out to what's this restitution gross yield? $670.
Yeah, that was
What's that for?
my understanding was negotiated by the cost that was associated with getting Mr. Minor, but again, I would.
Call him Mr. Wayne. Sir, if you plead guilty to operating while impaired, the possible penalties are as follows. Up to $300 fines, 93 days jail, 360 hours community service, court costs of law, 4 points, license suspension, revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon the record. You understand that?
Yes, Your Honor.
Did you sign an advice of rights?
Yes, Your Honor.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes, Your Honor.
Any questions before I ask how you proceed?
No, Your Honor.
To the charge of operating while impaired, how do you plead?
Yes, Your Honor.
Were you operating a motor vehicle in the township of Grosse Ile on January 10 of 2026?
Yes, Your Honor.
And prior to that, did you drink alcohol? And if so, what did you drink and how much?
I believe I had 2 or 3 Jack and Cokes.
What else?
That was it. And I maybe no more than 5. No more than 5 Jack and Cokes.
Okay, you said 2 to 3, and then you said no more than 5.
Yes.
So was it 5 or was it 2?
2 or 3.
It was 5, wasn't it?
It was 2 or 3.
So
I'm just asking how much you had to consume. Just relax.
it's okay. What the judge is asking, I think he's saying 5. What the judge is asking is how many drinks you have. If you're not sure, you're saying it was less than 5, or are you saying it was only 2 to 3? The judge wants to know. So I
And you want to be honest with the
Yes,
judge.
I want to be-
Some people walk in here, well, to tell you the truth, and they're not honest.
Yeah,
And we can read through them.
yeah.
So just tell me how many drinks you had.
I had two.
You had 2 Jack and Cokes.
Yes,
Was this at a bar?
yes.
So you're saying you only had 2 shots of alcohol?
But you were drinking more. The judge is asking, and I know you're nervous.
Don't be nervous.
Judge is saying not just those drinks. What did you have that entire time? So you had a Jack and Coke, you had some beer, you had a White Claw, whatever it is, let me know so that we can, one, be on the same page and get.
I've had 3 Jack and Cokes and I had 3 White Claws.
Okay.
I mean,
It wasn't so hard, was it?
for that BAC, that 2 Jack and Cokes does not make sense.
Why were you pulled over by the police?
Believe I had.
What do you think you did wrong? Forget what they think. I want to know what you think you did wrong.
First of all, give guy a little.
I know, but why were you pulled over? You were speeding, weaving, swerving? What
He was
happened?
on the side. He actually pulled over for safety on the side of the road. He was, the officers came up as he was already inside.
Where were you on the side of the road? What street?
I can't remember, Your Honor. I was following my GPS on my way home.
All right, so you pulled over on the side of the road and the officers approached your vehicle?
Yeah.
And did you feel intoxicated at that time?
No, Your Honor.
You didn't? This is a super drunk charge now. Be careful with me. Okay, come on, just tell me the truth.
Thank you, Your Honor.
No, I don't want you to lie to me either. I don't want you to guess. This isn't Jeopardy. Stop, listen to me. Just answer my questions truthfully, okay? Your appearance.
Hey, good morning, Your Honor. Matthew Wayne on behalf of the Township of Roseal.
Good morning to you, Mr. Lee.
Thank you.
So after you had 3 White Claws and 3 Jack and Cokes, you're driving in Groseal Township, right?
Yes, Your Honor.
What bar were you at?
I can't remember, Your Honor.
Was it on Groseal?
I believe so.
You don't know?
Oh, I was just following my GPS, Your Honor.
Were you drinking by yourself or with someone?
I was by myself. I was leaving Captain James.
In Wyandotte?
No, Captain Jones is in Gibraltar.
And you ended up on Groseal?
Sorry, I just
Okay,
it's on GPS.
okay, and it took you on to Groseal, right?
I believe so.
And,
Oh, I'm sorry. Yes, Your Honor.
and you pulled over because you were kind of feeling at that point that you were lost. Is that true or false?
That's true, Your Honor.
And then police approached your vehicle, right?
Yes, Your Honor.
And they put you through field sobriety tests, is that right?
Yes, Your Honor.
And then did they administer a PBT on the road to you, a machine, portable machine?
If I may, Your Honor, they did initially and then didn't register. And then I believe he reviewed the second time and they tried. So then they did a blood draw and that's how.
Is that right?
Correct, Your Honor.
And counsel, what were the results of the blood draw?
I believe it was 0.2. If I don't have the exact number, sorry, Your Honor, but we would stipulate to what the session.
3.26, Your Honor, I believe.
I'm sorry?
I believe it's 0.26.
That's correct.
All right.
So stipulate.
And you stipulate that was an accurate read. Counsel, one thing I'm going to ask that they do, so when I'm not criticizing, I'm going to come back to you here in a second.
Yes.
Not you. On these complaints, I need more information. There's no indication what road he was on. You got BAC of 0.17 or higher. There's no indication what street he was on. There's no indication of what it's just a form. And it really needs to be filled in, these blanks. These officers need to fill these in. They don't have what road he was on. They don't have what his blood or blood or intoxilizer results were. I don't look at police reports. It's inappropriate. Are you on probation or parole right now?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Now, how much did you really?
Okay.
You didn't have just 3 Jack and Cokes and 3 White Claws and get the 2.6. How much did you really drink?
I had 5 Jack and Cokes, a couple of shots and a couple of White Claws, 3 White Claws.
What kind of shots?
I believe they were, honestly, Jameson.
Okay. Why don't you tell me about that before? You're not going to be one of these guys lying to me, are you?
No.
Because a lot of them do. Like, I get the feeling it's either the way I look, talk, or act. That most people don't think I'm very intelligent. And I just ask people to be honest with me. You weren't very honest with me. And I don't appreciate that, okay? You made a big mistake. That's really high breathalyzer. You're over 3 times the legal limit. I'm going to accept you're not on probation or parole, you said, correct?
Okay.
Nobody's forced you to plead guilty?
Okay.
I'll accept your plea to operating while impaired, dismiss the super drunk, dismiss the OWI, and putting the plea on file 692. I'm ordering a screening and assessment. I'm going to set a bond. The only issue I have here is, how are you guys coming up with $670 in false recovery?
Yeah, for sure.
Yeah, but let me see. I can tell you that for decades here, you can hand it right to my reporter. I can tell you for decades here now, I've been capping the breathalyzers at 150 and the blood draws at 2.25. Now, maybe I need to revisit that, but I'm not going to order $670. I mean,
Yeah, I would just submit, I mean, I understand that,
it's got $670. He's going to get fined and assessed costs, and I don't appreciate him not being truthful with me. He seems like a real nice kid, to be honest with you. I mean, I haven't seen a lot worse, but
I mean, with respect on it, but I mean, aside from the defendant's demeanor, I mean, these are just the figures that the township provided. I mean, I believe they provided in honesty. And these are the rates, Your Honor, and that's what my client has. And I understand that of course, the court is well within its rights to depart from that, but that's to answer your question, Your Honor.
no. Mr. Wayne, I'm not picking on you. I'm just telling you that I get it. I'm just telling you that I'm not going to order. Let me ask you a question. You had 3 officers that had spent overtime on the arrest. They were all overtime. Don't answer that. I mean, that's a lot. 3 officers, that's a lot. I mean, so tell them that, you know, I'm not giving more than 2.25. And I'm not condoning his conduct. You don't think I'm condoning your conduct, do you? I'm quite sure that we should order a sober link on this.
In Your Honor.
What do you have to say? I'm going to address bond now. What do you have to say?
Oh, Your Honor, thank you. I was just gonna say, if you'll allow me to allow him to make a statement to you, Your Honor, whenever we're doing this, I think he wants to address what you just mentioned about not telling the truth, because he is a good guy.
What do you want to say to him?
I just want to say I'm sorry, Your Honor. It was really nervous here at the moment. I'm thinking about my future with my children. Yeah,
Future of your children.
future with my children. That's what.
Okay, but were you thinking about the future of your children when you were driving around over 3 times the legal limit? That's a good question.
No.
What does he do for a living? I'm just curious.
He's a mechanic.
Use your brains, will you?
Yeah.
Okay.
He's saying that because we had a conversation about.
You cannot, $1,000 personal bond, you cannot leave the state without the consent of the court to violate any law. You must appear in court as directed, attend AA 3 times a week. I want you going 3 times a week. I won't put you on a sober limit. This is the first offense, right? No alcohol, no marijuana, no illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. You don't need to leave the state for any reason, correct?
Oh, yeah.
All right, we'll give you you're going to then go over to probation, fill out a questionnaire and be interviewed. That's called a screening. And then you're going to the questionnaire is the screening. And then you're going to undergo an assessment, and we'll set a sentence date. You'll go over there and you'll get your first foot on the hall, get your notice. We give you a copy of the bond sheet. I'll put you in there. What do you have for me, Heather? This does not have to be on a gross yield day. We can do this any day. I'd prefer to do some of these on Monday when I've got a retained lawyer, when there's no restitution. If you can find a Monday, we'll just do it at 8:30. And
we have a probation docket on the 20th.
how are you on July 20th at 8:30? Oh, I'm asking your lawyer too.
Sorry, Judge, I'm sorry, you said July 20th.
Yeah, it's a Monday at 8:30. If you can't do it, you can't do it.
I can't do that, yeah.
How about the 27th? Am I here then? I think I am. Can you do the 27th?
27, yes, actually,
We'll do it the 27th. Did he hand you an AA sheet? You're gonna go every 3 times a week. You're gonna have that form signed. And you're gonna come to court, and every time you come to court, you have to bring it with you. You understand all the bond conditions.
Your Honor, I'm sorry, for your procedures, I was not, because I had to exit the courtroom and return some documents. I wasn't present for the entirety, but I believe this factual basis had the plea. Regarding the reason what brought the defendant to the Grossfield Police Department's attention, he was off the road. A portion of his vehicle was jutting onto the highway. I think that's important because that establishes the requisite probable cause for the Grossfield Police Department to investigate.
Is that true, sir?
100%.
Is that true?
Yes, Your Honor.
Don't lie to me again, okay? All right. Good luck. We'll see you back here. Nice. I think it's great what you're doing for this young man back here.
Thank you, Your Honor.
How long have you been a lawyer now?
2019.
Well, you're well polished for a 6 or 7 year lawyer.
Thank you, sir. I appreciate that.
Have a good day.
Brother Prosecutor. Thank you.
We'll see you here then. Thank you. What, Weirs, Randy Lynn Weirs, 24B14714.
Good morning, Your Honor. Deanne Patillo with 82378 on behalf of Ms. Randy Weirs.
Your name, ma'am?
Randy Weirs.
This wasn't marijuana. This was what kind of drug? You're not using cocaine, right?
Over 2 years.
This is going to be a plea to possession of a controlled substance under 7411, correct?
Correct.
If you plead here, ma'am, to that, well, you guys got HIDA. You want? No, she's not eligible for HIDA. She checked the box height.
You know what? I apologize, Judge. I meant to take that back in to take.
Yeah, would you do that?
Before.
Would you do that real quick? Amy, would you handle that and just go get that changed? And I'll wait right here for you. Thank you.
Thank you, Judge.
You got that changed?
Yes.
All right. If you plead guilty under section 7411, I'm going to defer the proceedings, set terms and conditions. If you're compliant at the end of that period of time, the prosecutor will move to dismiss and I will dismiss. If you're not compliant, the conviction will enter. Possible penalties on this are up to $500 fines under local ordinance, 90 days jail costs or all those. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
All right. You understand everything?
Yes.
For the charged possession of a controlled substance, how do you plead? How do you plead?
Guilty.
Were you on October 13 of 24, 3:41 in the morning on West Road near Telegraph in Brownstown Township?
Where was I?
No, I'm asking you, were you on West?
Yes.
Near Telegraph in Brownstown on October 13 of 24 at 3:41 in the morning?
Yes.
Were you in a car?
Yeah. Yeah.
And were you pulled over?
Yes.
Did you have some kind of controlled substance?
Yes.
What did you have?
Cocaine.
Okay. How much cocaine did you have?
Less than 50, which is a very small amount.
Less than 50 grams?
No, less than $50 worth
Okay. And where was the cocaine
in my pocket.
And the police confiscated that?
Yes, sir.
And it was yours? You put it there, right?
Yes.
Right? Are you on probation, parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted. I'll take it under section 7411. I'll refer you, I'm not going to accept it. I'm going to defer the proceeding, refer you for screening and assessment. You'll be screened and assessed today, sentenced at a later time, okay? Let me see your AA voucher. Or show them to your lawyer. Show them to Ms. Patillo.
Judge, also, I think it's notable that, okay, Judge, I see it.
Okay, so she's been going twice since I told her to on June 15th?
Yes.
She should have 4 on there, right?
Yeah, she has 4. June 19th, June 24th, June 26th, and June 29th at the Down River Unity.
You're not fooling around with cocaine now, are you?
No, I've been sober for 2 years.
Do you work?
I'm on unemployment right now.
Where did you last work and when?
Rose, New Boston, and my last day was in April of this year.
What did they do? What did you do there?
I made interior car doors for a Jeep Cherokee.
All right, I'm referring you for the screening assessment. You keep going twice a week. until that time, you are going to test weekly. I'm adding that provision. You're going to have to go talk to probation. I want you testing weekly. Okay, defendant, you test weekly. So we're going to take her over to probation, Ms. Patillo, make sure that they set her up for testing, if you would, okay?
Okay.
The sentencing date in this case will be on July the,
We can do the 15th.
At eight-
Can we do this one at 8:45?
sure, 8:45, okay? Wish you well. Good luck.
Yeah.
Thank you, Judge.
The problem brought these other two from Scotland, but it looks like he's not in Zoom and I'm in a bit with anyone's. Here's the other.
Yeah, see, I just wanted to arraign him. He's not on Zoom. Can we get Mr. Scott back on there?
Yeah, I don't know why they took him off because we had another one they were supposed to bring on after too.
Crawford, you can go do whatever else it is that you need to do, and when we get him back, we will take care of it. All right, I need the township attorney on Mr. Boyd.
This is just a stick to adjourn that's up for tomorrow.
Okay. I'm going to go ahead and sign this stip to adjourn on Mr. House sent over where he's got all these dates. What? You can't. If you have a problem scheduling a date, you tell me, Heather. I'm signing the stip in order. Mr.
Okay.
Boyd, Robert Thomas Boyd, 25B82557. I'm holding my, crossing my fingers. I'm crossing my fingers, Mr. Boyd, that you did what I asked you to do. I know you didn't let me down this time. I've given you so many chances. Your name?
Yeah, Patillo, B82378 on behalf of Mr. Boyd.
Your name?
Robert Thomas Boyd.
Your name?
Rob Harris on behalf of Brownstown Township.
Your name?
Caitlin Floyd Carter, Nebraska Township.
Do I dare ask?
Yeah, unfortunately, Mr. Boyd has made no progress since the last time we were here. He was also ordered, in addition to cleaning up the property, to at least contact the township to ensure that we did an inspection of the garage tear down was appropriate. He didn't do that. He hadn't contacted the building department whatsoever. Kind of at a standstill here.
Well, Your Honor, the garage was torn down. It is my understanding.
That was before.
We got rid of one trailer.
That was before.
So Judge, I know Your Honor has given Mr. Boyd several chances. He did have a summer cold over the last couple of weeks, so he wasn't able to do anything. But Judge, it's summer, so if he goes to jail, his neighbors, they have to keep looking at that stuff. Your Honor, I would just ask that the court would be willing to give him maybe a week or two just to see what else he can get done. I think if he wouldn't have gotten sick, then maybe he could have contacted the building department to make sure that the property could be inspected, to make sure the garage was torn down properly. But if he goes to jail for 80 days, his neighbors have to sit there for 80 days.
They can start an action from. I don't know why you're making my position so difficult, Mr. Boyd. I don't know why. I asked you, I asked you to get your son here. You said you don't talk to your one son. I asked you to bring your other son. He's not available on Zoom. He's not coming here, is he?
We're on the outs a little, the younger son.
You're on the outs with both of them?
No, my older son dropped me off today.
Why didn't what is your older son? I wanted to talk to him. Remember when I asked you last time to try to get him on Zoom and I think you called him and he wasn't available? Why didn't you just ask him to come in here?
He's working 12 hours a day on midnights.
Can we try to get his son in here next week, Judge, before you decide if Mr. Boyd is still in jail?
I'm not sure, I'm not sure you don't,
Get it, Judge. I don't know, this was a basis from April 2025.
but this has been going on for how many years again? 25?
Something like that, Your Honor. I think it dates back to 96.
So it's only been 30 years. This new addition here was built 30 years ago. I don't know what to do with you, Mr. Boyd. At the risk of sounding crazy, I almost feel like I have to order you to get a psychological evaluation at some point.
I'm working on it every chance I get.
A psychological evaluation. I think this is deep rooted. I don't understand it. You could have a nice place there. You're not working on it every chance you get. You didn't call the township. You didn't go to the volunteers. Didn't bring your son in here.
Hey, you know,
You are forcing me to do something I don't want to do. I don't know how much more clear I have been about this or could be about this. I don't know what to do with you, Mr. Boyd. You're the last guy I want to send to jail, but I don't feel like I have a choice. I just don't understand it. I do not understand it. Now I'm going to hear it's too hot. It's too hot, and it is too hot. I don't want you out there working on this. I don't think anybody should be working out in this crazy weather right now.
I can work in the morning and,
Mr. Boyd, what do you have on your wrist there?
I got carpal tunnel in both my hands.
You never wore those in here before.
Yeah, well, I wore.
Did you ever wear them in here before? I never saw those on you. How many times do you think you've been in front of me on this case?
I always wear my hurts.
I'm asking you, how many times do you think that you've been in front of me on this case?
I don't know.
Take a wild guess.
5? It's a wild guess.
I just don't know what to do. This is at least the 10th time.
Wow.
And I bet, oh yeah, I know. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Actually, I think this is the 12th time.
Wow.
Far cry from 5. And all I'm telling you is in the 12 times, I've never seen you wear those bands or wrists.
Work you got done.
I'm just telling you the carpal tunnel syndrome thing I've never seen before. That's why I'm asking.
Yeah. I just wear them when it hurts. If it don't hurt, I don't wear them. Mostly at night.
Heather, put Mr. Crawford in a breakout room with Mr. Scott, will you please?
Okay, Judge.
I'm sorry, I didn't hear you, sir.
Now, I'm going to revoke the 771 status and enter the conviction. I don't have any choice. I don't have any choice. At one point on this case, I remember I did something that had everything that he was left to do, that he had left to do. I need to resentence him.
I have the original sentencing on my end of it.
All right. Why is that not attached? It should be attached to my order. I need you to go to probation if you would. Go to Heather if you need to. Somehow I need that attachment to the order that I prepared when I sent. I am revoking your status. I am entering the conviction. I am going to resentence you. But I need to know what I originally had attached, because for whatever reason, it's not attached to the Register of Actions. And then I need you to take a second copy and you tell me what it is that I did or has been completed. And we'll have him back in a little bit. You're just going to have to be patient, Mr. Boyd, okay? Thank you. Okay, good. So we'll want that attached. Can you guys attach that to my sentence, please? And then you're going to give a copy to her that she's going to write on and indicate what has been done exactly, or you guys can, and we'll from there. Thank you.
Thank you, Jay.
Are we ready on Mr. Johnson? Recalling Oratorus Brandon Johnson, 260-150198A and B.
We have the TOP 82378 on behalf of Mr. Johnson.
Mr. Johnson, your name.
Taurus Johnson.
So I indicated I was not taking the case pursuant to 7411 on file B. I began my sentence. I actually, for the most part, completed that, went on to the attempt RNO. And then that's when he started to tell me he didn't do anything wrong, essentially. That's so many words. So I offered to allow him to withdraw his plea. What would he like to do?
So, Your Honor, he doesn't want to withdraw the plea. What I believe happened, Mr. Johnson saw police behind him, but some of the police kept going. Even though the officer that got behind Mr. Johnson said that he's going to be pulled over for his plate, I would imagine he was also going to pull Mr. Johnson over for not stopping when you saw emergency lights. So Mr. Johnson continued to go up the ramps, even though it was police behind him. So he didn't run, he just should have pulled over, and he did not pull over until about a mile.
This was at 2:00 in the morning, right?
Right. So if we have a trial, the jury.
There weren't a lot of cars around at the time, were there?
It was just.
Yes or no?
I'm not sure. It was like 6 police officers, cars flying by me, so I didn't know they was behind me or what. They went past me. I came up off the.
You had an officer following you for how long?
I'm not sure.
You don't know? Could have been more than 10 feet?
I'm not sure. Like I said, the officers, there was a bunch of police officers passing me. I don't know when he got behind me when he started trying to pursue me. I never went up the speed. I never got off the track of my home.
Judge, I believe it was from the exit of the freeway to Mr. Johnson's residence.
Observing that the vehicle was not pulling over to the right, I continued to follow the vehicle with my emergency lights and sirens activated. The vehicle proceeded to exit I-75 and turned onto West Road traveling westbound. The vehicle continued traveling westbound through Gudith and then through Fairway Drive. The vehicle proceeded to travel westbound west through Westwood Drive before turning onto East Lorraine. The vehicle then came to a stop for a brief moment before moving again. The vehicle then came to a complete spot. During this vehicle pursuit, the vehicle continued to flee and did not stop. The top speed of this pursuit ranged from 30 to 41 miles per hour with no traffic on dry roads. Where were you going at the time that this officer was following?
When I stopped at the speed bump, I was alone.
Where were you going?
I was alone. The complex that I pulled it is where I stayed.
So you had no idea this officer was following you?
No, Your Honor.
The car that I was driving was not, they usually leave there. What's the name, tilt it down and I didn't touch anything in the car. When I came up, it was police officers going past me. They kept going. I thought I was getting out of their way by coming up off my exit, and one must have still got behind me. So as I drove,
Call him Ms. Foley Carter.
Regarding from the township.
I don't remember the exact nature of the factual basis that I took on this RNO case.
Kevin, for you, Aaron?
Yeah, I read the report. He's denying knowing that they followed him now,
Yes.
that they were following him.
Time to do evacuate a traffic stop at Sibley on 75 due to the plate being expired. Mr. Johnson continued on. He eventually exited at the West Road exit, continued down West Road in Mary Manor. That was roughly 4 miles. The officers had, it was at night, so, and with his lights on, the officers had to effectuate a felony stop due to the fleeing only situation.
Is any of that refreshing in your recollection?
not that he was behind me, but when I did notice that the police was behind me, I was pulling over, and that's when another one came to the front of it. That's when I got out the car, and I actually told the officer I didn't know it was behind me. I never.
We got a police officer with oscillating lights at 2 o'clock in the morning following you for 4 miles, and it didn't dawn on you that he might be asking you to stop?
I didn't believe it was 4 miles. I came about the freeway. When I came about the freeway,
did you go?
Eyes come up high.
And if I may, when used the body cam footage, Mr. Johnson told the police that he didn't know it was for that him to be pulled over.
Yeah, because they was going by me. Like 3 other police officers went by. So when I came up, I just came up on my regular takes. I mean, I didn't know.
And you're saying it was 4 miles?
It was from the exit of Sibley Road on 75, all the way up to Marion Manor back. So he went through Woodhaven into Brownstown.
Okay, listen. Do you dispute anything she just said?
I don't remember being on Sibley. I was just on the freeway and I came up on the West Road.
Sibley, yes.
Oh, Sibley, yes, no.
Look, I was satisfied the first time there was a factual basis. I don't take pleas unless there's a proper basis for them. You're saying he doesn't want to withdraw his pleas, certainly based on what I heard at the time, what I've read in the report, what the prosecutor's saying. Any reasonable fact finder could find that there's proof beyond a reasonable doubt. I'm just going to go ahead and sentence him on the R&O charge. I'm taking it under 771.1. You're free to go. I've already announced everything that I'm doing on the possession of controlled substance. And I'm simply going to run these concurrent. I will not violate you not because I think I like this, but because the law is that you can use medical marijuana. So if you test positive for if you have a valid medical marijuana card and you test positive, I will not violate you. If you don't have a valid medical marijuana card and you're positive for marijuana, that will be deemed a violation. I'm going to repeat my sentence, 12 months probation. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed, report to probation as directed, no alcohol or illegal drugs or marijuana. I will not violate you if you test for THC marijuana, so long as you possess a valid medical marijuana card. You're going to submit to chemical testing, PBTs and ETGs as follows: weekly for a month, bi-weekly for 2, then monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. AA, twice a week until an outpatient treatment. Once you get an outpatient treatment, you no longer have to attend AA or NA. 1 day on the court work program, there's a $35 charge for that. I'll put that on the possession of a controlled substance charge. 3 days of community service by September 10th. 12 months probation. 150 fines. This is all on the impaired chart. 150 costs, 75 victims' rights, $50 justice assessment. That's 4 1/4. Screening fee 60 for 485. Probation fees are 240 for 725. Seek court work program fees are 35 for 760. On the other file, I'm running all those same terms concurrent. Every single one of them. We're going to do a day of court work. but I'm not going to charge you again. 3 days community service by September 10. All those same terms will apply. They're all running concurrent. I will only charge you, I won't charge probation fees on this file. I won't charge, and I'm talking on the R&O charge. I am taking it under 771. Fines 100, costs 50, 75 victim's rights fee, $50 justice assessment, 275. That's all I'm going to charge you. I am going to add another $40 on attorney fees on that file, 315 or 90 days. I'm going to give you a review hearing date. If you're compliant at the end of the specified 12 months, I'll dismiss that on their motion, and they will move to dismiss. So you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. So you have 760 and 315, which is 1,075. He does not, I don't believe, have a bond. Can he pay all of that today? How much do you have today, sir? Why not? You're not taking this seriously.
No, I was. I've been here 6 times on this case. I have used 6 days of work. He's an FMLA, so I have my paychecks spent on this stuff.
All right, but don't blame us. You were here 6 times.
No, I'm not blaming you. I'm just saying.
Yeah, I mean, you came for a pretrial on February 18th. I arraigned you, March 19th, rather. March 19th, then we set another pretrial at your request on May 20th. Then you wanted a jury trial. I set a final pretrial for June 17th, jury trial for July 24th. You came here June 17th, and you're here today. So you were here 4 times, not 7 times. If you came here on some other case at some other place, that's fine, but you were only here 4 times. That's what I'm doing. I'll let you pay this. I'll let you set up your payment plan at a reasonable basis. Tell me what you can afford to pay and when. How much a week?
I get paid bi-weekly.
Tell me how much bi-weekly. I'm sure. I'm sorry.
I'm not sure.
You sure you can do that? You don't have to do that. I'll let you pay 75. When's your next check?
Next week.
What day? Friday? So you're going to get paid on July the 10th?
Mm-hmm.
Yes?
Yes, sir.
You're getting July the 13th. 75 bi-weekly. He's going to pay first, Heather, on the 198A case, and then 75 bi-weekly on the other file. And that.
It's
So I want you to repeat this. With the wrong kid.
I think we'll. So
You're welcome. Come on up here, Mr. Boyd. Call in the prosecutor. Good luck. Go down the hall.
Thank you, John.
Get your sentence date. We'll see you back here. It's a paper notice. Mom, thanks for bringing him, okay? He seems like a nice kid. Let's get him on the right track, though. You're welcome.
Right. Yeah, right.
2 830s that haven't been brought back up.
Where's 2 830s that haven't been brought back in, Judy?
It's a miracle. I don't know who has.
Are they here?
Yes, they checked in and.
Well, let's go dig them out. Will you, John, please?
Let's get him definitely.
I don't know who was telling us.
Call in Ms. Patillo, too. In fact, I'm going to take a 5-minute recess. I need Ms. Patillo on this one, gentlemen and ladies.
I'll get her.
And I'm.
Yeah, well, she was in Woods County, but it looks like she's out.
Okay. We're going to call Mr. Boyd. I know you probably haven't had a chance to go through that. At least I didn't get it, and I don't want it right. People against Robert Thomas Boyd, 25BA 2557. Mr. Boyd, your name?
Robert Thomas Boyd.
Yeah, Patillo, B8 207 on the 5 of Mr. Boyd.
Caitlin Foley Pardon from Township.
Rogers from Township.
Do you have a document that you've had a chance to go through from the original sentence that tells me what is and isn't up to the satisfaction of the township?
Yes.
Can you provide me with a copy of that? And have you provided a copy of that to Ms. Patillo?
Ms. Patillo has.
Can I have a copy? I'm not going to sentence him today. I've entered the conviction. I am going to clarify with this. You're telling me, do you have a copy of this?
That's the original copy. I understand that he hasn't complied with any of them. Technically, I think the only one that's not relevant is book storage.
So when you wrote down F, what does that mean? So he has 2 vehicles parked on the grass still. There's multiple flat tires on the RV in the car. Winter boat storage only permitted on residential waterfront surfaces. You just checked an X there.
It's not relevant right now because not.
Ms. Patil,
Yes, Judge.
I'm gonna have you make a copy of this. We're gonna make a copy for you. We're gonna make a copy for the prosecutor. This is going in this file. I'd like you to sit and talk with Mr. Boyd. I realize the weather's going to be hot. Mr. Boyd, I'm gonna shock you one day because I'm gonna have to send you to jail for a long time, and I don't want to do it. I just don't want to do it. How old are you? Copy, Ms. Foley Carter and Mr. Harris get a copy, and we're gonna leave a file copy in here, and I'll decipher it with everybody, but you're going over it with your client. You know what the prosecutor's asking for, and we'll go from there, okay?
Thank you, Judge.
Mr. Boyd? I know I've threatened you several times, not threatening this time. I'm just telling you that if you don't have it all done, I gotta do what I gotta do. And I'm gonna feel awful about it, but I can't give you any more time, sir. I'm giving you 4 more weeks, that's it. Otherwise, I'm gonna have to do what I don't wanna do. Ball's in your court. If I had a extra set of keys to the jail, I'd throw them to you. I'm serious. I'm not trying to be funny here. Because you're gonna determine whether or not you're going to jail. Good luck. Thank you.
Thank you, Judge.
Ms. Patil, would you please do your best to reason with this gentleman?
Yes, Your Honor.
Thank you very much. Obviously, I've failed on this. Do we have another file down there?
Ms. Patil's case.
Yes, sir. State your name, please. Hayden Beaver. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the 3rd degree. That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that? Yes, Your Honor. Understanding that, you still wish to plead guilty? Yes, Your Honor. To that charge, how do you plead? Guilty, Your Honor. Now, you understand that by pleading guilty, you'll not have a trial of any kind. Yes, Your Honor. All right. You signed an advice of rights form. Is that correct? Yes, Your Honor. Any question regarding any of those rights? Yes, Your Honor. Look on the podium. Please look at paragraph 5. Those rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes, Your Honor. You understand you're giving up your right to appeal of right. Yes, Your Honor. You on probation or parole? No, Your Honor. Has anybody promised you anything other than what's been stated here today to get you to plead? No, Your Honor. Anybody threaten you or coerce you? No, Your Honor. You're doing this voluntarily and of your own free will? Yes, Your Honor. And because you believe that you're guilty of this offense? Yes, Your Honor. February 15, 2026 at the location of that's 7000 East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan. What did you do at the Walmart that makes you think that you're guilty?
May I, Judge?
Man.
Hayden, did you go into the Walmart?
Yes, sir.
Was it open to the public?
Yes, sir.
Did you take property belonging to Walmart at a value of any value, but something under $200?
Yes, sir.
And you were apprehended?
Yes, sir.
You had no permission to take that stuff, right?
No, sir.
So you're guilty of retail fraud, 3rd degree?
Yes, sir. All right. And just so that we're clear, you intended to walk out of that store without paying for it? Sir. Yes, Your Honor. All right.
Thank you, Judge.
Sir, I do have to advise you that on the court, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that? Yes, Your Honor. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, the retail fraud 3rd. Count 1 is dismissed. Defendant's referred to probation for a pre-sentence investigation and report and determination of height of status. Sentencing in this matter will be
July 22nd at 9 a.m.
July 22nd, 2026, 9 a.m. As the bond in this case.
Thank you, Judge. I would ask for a personal bond. He's here today. He's retained me. He's got no prior record. He is a college student. Obviously, the support of his family, his dad being here. It's my understanding from reading the police report and everything else. There was no alcohol or drugs involved in this case. So I just asked for the standard general terms and conditions and asked for a personal bond. Thank you. Obviously not to enter Walmart.
Pardon?
Obviously not to enter that Walmart.
I will make that a condition, but where's he in school?
He's at U of M.
Oh, in this courtroom, that's Maryland, but you mean that one down the road?
Yeah, down the road.
All right, just thought
down the road, really close to here.
How old are you? 19, Your Honor. So you just finished your first year? Yes, Your Honor. What are you going to be when you grow up?
Thinking project management, although
what?
Project management, potentially for a construction company, Your Honor. My dad owns a construction company, so maybe I'll get into that later. We'll see where I end up.
Okay. Bond is setting at $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. No possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will also order that you are not to enter any Walmart store in the state of Michigan. You understand that, young man? Yes, Your Honor. All right. Well, tell you what, you ought to stick to that project management because as a thief, you're not very good at it. Okay?
Yes, Your Honor.
Thank you. See you later. Thank you, sir. Court calls the case of the People versus Carla Bristow.
Morning, Your Honor. Raymond Cook, People.
Good morning, Your Honor. Alexander Hermanowski.
Hold on one moment. Have him stop down at probation. It's on the left-hand side on his way out. Thank you. Go ahead. I'm sorry, Mr. Hermanowski.
Alexander Hermanowski with and on behalf Carla Bristow, who's appearing by Zoom. Carla, please state your name for the record.
Carla Bristow.
Your Honor, this is time and date set for a pre-trial. I've had discussions with Mr. Cook, and we are close to a resolution. However, we do need some time to iron that out. Instead of asking for another adjournment in a couple of weeks, if that happens, we're asking for an adjournment in August.
You believe that you'll resolve this?
One way or another, well.
Because there's a co-defendant's case that we're sort of trying to resolve along with this one and tracking along. That one got adjourned to July 20th. We were hoping to have an answer this past Monday at the last pre-trial, but it ended up getting adjourned, so we don't have that answer today. I am hopeful that July 20th we'll have an answer, but I can't promise that.
Why don't I set it for final settlement conference in August? If you're looking to get into August, let's do that so I can move the case along.
Yes, Your Honor.
I'll set jury final settlement conference for August 7th, 2026 at 9 a.m. Jury selection, if necessary, will be August 10th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Bond will continue.
Have a good day, everyone.
All right, take care, Mr. McNally. Court does call the case, People versus Michelle Knoll.
Your Honor, Raymond Cook for the people.
Your Honor, good morning. This is Matthew Mansour. I'm here on behalf of Miss Michelle Knoll, who appears via Zoom. Michelle, can you please state your name?
Michelle Knoll.
I have before me a plea form that indicates that she will be pleading guilty to the charge of retail fraud third degree. That's as charged. There is a sentence agreement of fines and cost. Where is all right. She will likely have to go to probation. I'm not saying that I wouldn't sentence her to fines and costs, but she will have to at least meet with my probation department. So if that doesn't fit with the resolution of the parties, then I need to know that now.
I'll leave that. So I believe the people submitted a sentencing memorandum where believe that fines and costs is appropriate, but of course the court wants full PSI before making that decision. And people have no objection if defense doesn't make it correct.
Your Honor, that's reasonable to me. We have no objection. Whatever the court deems necessary, we are willing to do it.
All right. Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record.
Michelle Knoll.
All right, ma'am, it is this court's understanding you're going to be pleading guilty to the charge of retail fraud in third degree. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or had one signed on your behalf?
I believe so.
Your Honor, I went over the advice of rights verbally. She consents.
Yeah, but I don't have a. Did you send in a signed copy?
I
No.
did, Your Honor.
Pardon?
I did not know.
I'll need a signed copy of the advice of rights from either her or if she permits you to sign on her behalf. She's now frozen, I think. Ms. Knoll. All right, counsel, I can do it one of two ways. I can put this over for the taking of this plea, or what we can do is you can try to get that with your client, email it, and then I'll call the case up. Which would you prefer?
Your Honor, I can email it. That's okay.
All right.
Thanks.
Then I'll pass the matter and we'll await that.
Thank you.
Thank you. And your client's frozen again, so she's what we're going to do about that. Court does call the case, People versus Richard Bauer.
Your Honor, Raymond Cook for the people.
Good morning. This is Middleton, Laura. I'm hearing on behalf of Mr. Bauer. Your Honor, I have not had contact with Mr. Bauer. I attempted to get in contact with him. I don't have an explanation for his medical diagnosis.
And just so that you're aware, there's a community corrections bench warrant on felony possession of meth also. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls the case of the people versus Ryan Brown.
Morning, Your Honor. Raymond Cook for the people.
Good morning. First of all, for the warrant, today on behalf of Mr. Brown. I also attempted to get in touch with Mr. Brown. I was unable to do so. I don't see here in the court my no an explanation for his failure.
Having a good day, Owen. All right. Well, just to go along with the other 4 warrants. Bench warrant will issue bond $7,500, 10% privilege. Warrant will issue immediately. Court does call the case of the people versus Shamika Kurtendall.
Your Honor. Raymond Cook for the people.
Good morning, this is public. I'm on attorney on behalf of Curtis Hall. Who should be on Zoom, Your Honor. She is. Oh, thank you.
Yay.
Hello.
Hello.
Hi, good morning.
Good morning. Do you have a camera?
Yes. Oh, let me see. Can you guys see me?
Yes, I'm talking to you.
Okay, yes. Can you see me?
Yes.
Oh, if I could see you.
Yes.
Oh, I thought she said, are you talking to me? Yes, I can see you.
Okay, good morning.
Good morning. All right, I have before me a plea form that indicates that the defendant will be pleading to count 2 of no valid operator's license on person in 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
That's correct.
Ma'am, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Shamika Kurtendall.
Okay, you can put your hand down. Ma'am, it is this court's understanding you're going to plead to the charge of no valid operator's license on person. That's a misdemeanor, punishable by up to 90 days in jail and a $100 fine plus court costs. Do you understand that?
Yes, sir.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Yeah, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today on the record?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of November 13, 2025, West Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Did you get stopped by the police?
Yes.
Did they ask you for a driver's license?
Yes.
And were you unable to provide a valid operator's license?
Yes, I was unable.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Said, Father.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you want to say before I do impose sentence, ma'am?
No, sir.
Fines and costs of $200. I'll suspend 90 days in jail. When do you think you can get that paid?
Is it possible I can get on like a payment plan? Could I do that?
Okay. What are you proposing for a payment plan?
Could I do like, because right now I'm in between jobs. So could I do like maybe $50 a month?
Aaron's fault. This is too hard. What's 4 months from now?
October 1st.
October 1st. Pay this by October 1st,
Okay, thank you.
2026. Thank you.
Thank you.
Court calls the case of the people versus Otis Elliott.
Your Honor, Raymond Cook for the people.
Ron Brown hearing on behalf of Mr. Elliott. Mr. Elliott.
Ever. Oh, not here. You don't know where he is. I take it.
Well, I talked to him.
Yeah.
Yes. We stipulated to adjourn the case last time because he had some matters in Oakland County.
Right.
We were just going to set it for final settlement.
Well, he's got to be here for me to do that. Bench warrant, $7,500, 10%. Warrant will issue immediately. Court calls case of the people versus Haley Force.
Well, Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Force, who should be appearing via Zoom.
Yes. Oh, there she is. State your name, please.
Haley Force.
Thank you.
At this time, Your Honor, we requesting to set this matter for final settlement conference.
Jury final settlement conference will be set August 7th, 2026, 9 a.m. Jury selection, if necessary, August 10th, 2026 at 8:30. Both of those proceedings are in person. Bond continued. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. Court calls the case of the people versus Terrence Hall.
Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Hall.
Mr. Hall, can you state your name, please?
Can you state your name again, Mr. Hall? I think you were muted when you stated your name, but you're unmuted now.
Terrence Hall.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of allowing an unauthorized person to drive a motor vehicle, the 90-day offense. Upon a successful plea, that charge, count one, would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
Mr. Hall, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name again.
Terrence Hall.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to an added count 2 of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Do you understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form or had one signed on your behalf?
Yes.
Any questions regarding any of those rights?
No, sir.
You understand you're giving up those rights as well as the rights, particularly under paragraph 5, which are your trial rights. Do you understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, but I'm on tether right now for a different case.
He's on bond for another case, Your Honor, but he's not on probation or parole.
Thank you.
And this predates the bond in that case.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yeah.
And because you believe that you are indeed guilty of this offense?
Yes.
That was a better one. November 19, 2021, at the location of Gulfside Road in Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
No.
Fines and costs of $250. I'll suspend 90 days in jail. When can you get that paid?
I could pay it by next month. Like before next month. Immediately. As soon as possible.
Okay. So if I give you August 3rd, you can get it done by then?
Yes, sir.
All right. Pay it by August 3rd.
All right.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Jacob Hodge.
Morning, Your Honor. Raymond Cook.
Good morning. This is Middleton and Lauren hearing on behalf of Mr. Hodge. Mr. Hodge, state your name for the record, please.
Jacob Hodge.
Oh, there he is.
I'm asking for an adjournment. I think we are on our way to resolving this case. Mr. Hodge also has PCC in front of you tomorrow. Mr. Cook has made an offer on, so I think we're gonna hopefully wrap him up. Yeah.
Good. So it's my next day.
Fine.
Pardon?
July.
Will that be enough time for you guys to
I hope so.
adjourn the matter July 15th, 2026, 9 a.m. Bond continued. Thank you.
All right, thank you.
Court calls case People versus Richard Larson. Is it Ashflow?
Your Honor, Raymond Cook for the People.
Stand right here. Good morning, Assistant Public Defender Lauren Perny on behalf of Mr.
Richard Larson Asplund.
Larson Absalon. Okay, couldn't remember the two parts. State your name for the record, please.
Richard Larson Asplund.
Your Honor, why I'm requesting an adjournment. There are things that Mr. Cook and I are communication about.
Will the 15th be enough time or you need more time?
Frankly, I think we might need a little bit more time.
August 5th. Adjourn the matter to August 5th, 2026, 9 a.m. Bond will continue. Thank you. Thank you. Court calls the case People versus Sean Moyer.
Your Honor, Raymond Cook for the People.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Moyer. Yana, on this one, maybe a vote.
Yeah, I see him. Mr. Moyer, can you state your name again, please?
Sean Moyer.
Thank you.
Maybe a vote, Your Honor.
Asking for an adjournment on this matter. I was just appointed to it yesterday and filed the request for discussion.
Your name, sir?
That's Laurie. How you doing, Judge?
I'm doing well. All right. You were just appointed on it.
Yesterday, yes.
You want the August date, the first August date? Would that be better for you? Okay. Hearing the matter to August 5th, 2026, 9 a.m. Bond will continue with its conditions. All right, sir?
Thank you, Your Honor.
Fred, your recall is ready. Here is the advice it raised.
Court recalls the case of the people versus Michelle Knoll.
Morning again, Your Honor. Raymond Cook for the people.
Good morning again, Your Honor. This is Matthew Mansour on behalf of Miss Michelle Knoll. Michelle, can you please state your name again?
Michelle Knoll.
All right, I'll pick up from where we left off. Miss Knoll, you now signed or had signed on your behalf an advice of rights form. Is that correct?
Yes, sir.
You have any question regarding any of those rights?
No, Your Honor.
All right. You understand that you're waiving all of those rights, inclusive of the rights under paragraph 5. Ms. Knoll?
Yes, I can hear you. The Zoom keeps freezing. Sorry.
Got it. No, it's okay. But you understand that you're waiving all of those rights, including the rights that are contained in paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
Yes, sobriety court probation.
All right.
That's been. Go ahead.
Were you on probation in April of this year?
Yes, Your Honor. To answer Ms. Knoll, I got you, Ms. Knoll. So she's in sobriety court, and she's addressed this violation. She's admitted to it, and there's going to be no new violation for this.
So, but I do have to advise you, ma'am, that if this is considered a violation, that other court could sentence you to the maximum allowable under the other charge. You understand that?
I do, Your Honor. I actually graduate tomorrow. So from sobriety court, that's been addressed. As soon as it happened, I told my probation officer immediately.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Ms. Knoll?
Yes, I can hear you.
Did anybody promise you anything other than what's been stated here today to get you to plead?
Guilty?
Well, did anybody promise you anything other than that there would be a fines and cost sentence?
No.
Has anybody threatened you or coerced you in any way to get you to plead? Good morning.
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
I do.
All right. On the date of April 1st, 2026, at the Walmart at 7000 East Michigan Avenue in Pittsfield Township, what'd you do that makes you think that you're guilty?
Well, I attempted to leave the store with property that I did not pay for.
Okay. And this property was property that Walmart was offering for sale?
Yes, Your Honor.
And the store was open to the public? Did you hear that, ma'am?
No.
Was the store open to the public?
Yes, sir.
All right. And you didn't have anybody's permission to take that property, did you?
No, Your Honor.
All right. There's no restitution.
That's correct, Your Honor. As far as I'm aware, all the property was recovered.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor. Thank you.
Ma'am, you graduate sobriety court tomorrow? Ms. Knoll?
Yes, Your Honor, I can hear you.
All right. So you're graduating your sobriety court tomorrow? Is she hearing me?
I think she tried to say yes, but it
Yeah.
hung up on her end. There you go.
Yes,
Okay.
I am graduating tomorrow.
How long have you been in sobriety court?
Tomorrow makes 2 years.
This then was just a hiccup along the way, right?
Yes, sir. I've addressed this. Like I said, I got honest with my probation officer immediately and called my sponsor right after, and we're working on impulse control. And then I sought therapy for like behavioral therapy type stuff. But I'm looking to get another therapist.
Gotcha. All right. Anything you want to say before I impose sentence?
I just want to say that I apologize to the court for my actions and my behaviors. I truly feel like the sobriety court program has taught me a lot, and it's just taught me accountability and then the consequences of my behaviors and actions. But it's also taught me a lot about giving myself grace when it comes to matters and mistakes, like hiccups, like you just said. So yeah, that's about it, really.
I don't think you could have summed it up better as to what it's supposed to do, Ms. Knoll.
It's young.
So I'm going to do this. Fines and cost of $250. When do you think you can get that paid?
I can pay that. Can you give me like within the month?
How about I give you to August 31st?
Oh, that's doable. Okay.
All right. Pay it by August 31st, 2026. I'll suspend 90 days in jail, and I'll offer you my heartfelt congratulations on your graduation tomorrow.
Thank you. Thank you so much, Your Honor.
You're welcome. You take care of yourself.
I will. You do the same, okay?
Yes, I will.
Same.
He signed in from the hospital. Court calls the case, People versus Grant Jusia, or I know I pronounced it wrong, but day.
Good morning, Assistant Public Lawyer here on behalf of Bay.
Sir, can you state your name, please?
Brad Matthew Duche.
Duche, yeah.
Your Honor, I was unable to meet with Mr. Dussey. I'm not really sure how to facilitate bail. I'm gonna figure that out if he remains in the hospital.
All right, he's in the hospital at this point.
Right, he's in custody. He's under the jurisdiction of the Washington County Jail,
But he's it. I gotcha. Okay. So why don't I adjourn this then out just to the 15th? And we'll see. 2026 at 9 a.m. All right.
Can I ask him, Your Honor, if he knows how long he's gonna stay?
Well, I don't want to really put his medical out there.
Fair enough.
Why don't? So I'm not going to let him answer. I'm not going to do that. Typically, if you contact the jail, they're going to have a sort of estimation of that kind of thing.
Okay.
All right. Thank you, sir. Be well, please.
Thank you, Your Honor.
That's 10 a.m. So I'll step off, get our 10 o'clock lined up, and then come back. What, Kilowald?
For me.
What? Why are you like scooching around?
I mean, I was Judge Washington's court, but I had a 9 o'clock. Mr. Hawker, Jonathan asked for an adjournment. I have to be in here. It was like at 1 o'clock for a hospice minute. So.
Is his client in custody?
This client is not in custody.
He's on Zoom.
Is he in?
No, I actually don't have him.
What? That's what I'm saying.
Court calls because the counsel was whining with his hand. The cases of the people versus Dean Hawkins.
You don't file anything in 034. A conduct on behalf of Pittsfield Township in 073 and 163.
Good morning, I'm Rob J. Kilwell. Judge, I'm on 0324.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Halter and the other matters, 0273 and 163.
Your Honor, I was just
Noted that Mr. Bukovich was patiently waiting, but go ahead.
Judge, first of all, I do appreciate you are the most considerate judge I've ever known. So I do appreciate you being like you are. And I was disappointed yesterday for Mr. Halter. And if I didn't have this kind of emergency up north, I wouldn't.
I got you. Will the 15th work for you?
Of September? I mean August. What?
He's talking, yeah.
Who is that?
Unnamed individual.
I believe Mr. Halter's son.
What's your the person talking now? That's Blue Studio Mini. What's your name?
Yeah. Dean Harder.
Okay, that's him. He's
here. Yes.
So you want? You know what? You confused. You want the 15th of July or August 5th?
August 5th.
I was also be asking for an adjournment, Your Honor, so.
August 5th. All three matters are adjourned to August 5th, 2020.
Judge, I want to wish you and your staff a happy 4th, and I do appreciate your consideration.
And to you, Mr. For the best. I do. I think so. And I'm going to let the other 7 know you said that. All right. Okay. Anything else I can take care of quickly before somebody else starts whining?
I've got a short adjournment. Thank you.
If it's Fikowski, no.
You put my name in there?
Of course, going to stand in recess.
All right.
You're welcome.
Just let me know. Maybe second right.
So I'm sure to affirm the testimony about the whole truth and nothing but the truth of God.
Yes, sir.
State your name.
Joshua Hamlet. Sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that? Your Honor. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes, Your Honor. You signed an advice of rights form, is that correct? Yes, I did. Any question regarding any of those rights? No, Your Honor. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form. Yes, Your Honor. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today to get you to plea? No, Your Honor. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily and of your own free will? Sir. And because you believe that you're guilty of this offense? Yes, Your Honor. On the date of February 15, 2026, at the location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle? Yes, Your Honor. You allow someone who is otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle. Yes, Your Honor. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Anything you want to tell me before I impose sentence?
Just that I appreciate the opportunity to continue getting my license back fully reinstated so I can enjoy the privileges of having that. Thank you.
Fines and costs of $250. I'll suspend 90 days in jail. When do you think you can get that paid?
Within 30 days.
So you can pay before the end of this month? Yes, sir. You do 31st. Pay by July 31st, 2026.
Thank you.
All right. Thank you, Bond. Continue.
Judge, happy holiday, dudes.
And to you.
See you soon, I hope.
Court does call the case. People versus Devon Gibson.
Morning, Your Honor.
Good morning, Your Honor. Jonathan Sachs for Mr. Gibson for both his matters, and he is coming up right now.
Evan Gibson. Thank you. All right, what are we doing?
Your Honor, requesting a final settlement conference for both cases.
All right, you guys are this.
Okay.
Patient. Okay. Jury final settlement conference will be set August 7th, 2026 at 9 a.m. Jury selection will be set August 10th, 2026 at 8:30. Both of those proceedings are in person.
Your Honor, I apologize. I'm out of town on August 7th.
Is he in custody on something else or?
He is in custody also on a probation violation. I was going to ask also to address bond though.
Okay, well, with regard to the August 7th date, the problem's going to be is that we only select every other month. And so that in October is a weird in terms of scheduling that because our jury selection doesn't occur until the 19th. And therefore it will be the 16th. It'd be mid-October.
Is there anything in July yet?
What do you mean?
Any opportunity for a final settlement conference in July? No.
Your Honor, I'm wondering if what might work is if we could adjourn this matter 2 weeks to the 15th. His probation case is up tomorrow, is my understanding. From communication with the defense counsel, there's indication that the circuit court may release their hold on that case, but we should have an answer by the 15th. And if he is no longer being held on that case, we could address bond on this case and then set it at a later date because he would no longer be at or in custody at that point. That way we're not holding him an extra 2 months in custody if we don't need to.
Your Honor.
I apologize.
Your Honor, I think that's a great suggestion. I'd leave it to the court's discretion.
I don't. No.
Will to respond to it.
Okay. Let me just do this. Why don't I sort of take that suggestion both ways, but what I'll do is I will just adjourn the pretrial out. I'll leave the August dates in place for custody. So I'll adjourn this out to the July 15, 2026 at 9 for a pretrial. I'll leave the August 7th, August 10th dates in place in case it's necessary. And maybe, counsel, what you can do is if things don't resolve on the 15th, rather than delaying his action, you could have somebody appear in your place, in your stead on the 7th.
Yes, Your Honor, I think that will work.
Okay, we'll do it that way. All right, Bond. Oh, go ahead. Did you want to address?
No, Your Honor, I'll wait till the 15th then.
All right, Bond will continue. Let's take this copy. Court calls case People versus Kristen Bird.
Conrad Siller on behalf of Pittsfield Township.
And Assistant Public Defender Nicholas Buckovich on behalf of Ms. Bird, but not with the honor.
Really? Why?
Yeah, I did attempt to contact Ms. Bird with the contact information we had on file, but the email bounced back and the phone number is currently out of service. So I have no contact information.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000 to give a 10% proof.
Mr. Your Honor.
All right, yes. Court does call the case of the people versus Nicole Henderson.
Morning, Your Honor. Raymond.
Good morning, Your Honor. Nicole Sadi. I am substituting in as counsel. I received Mr. Brown's permission. I'm signing the slip with permission and emailing it to the court. I was just retained in on this matter.
All right, go ahead. You may proceed. Your name?
Paul Henderson.
All right, what are we doing?
Your Honor, there was a bond motion up. I understand that this honorable court wanted Ms. Henderson to get an assessment prior to determining whether or not to lower her bond. I was in contact with Mr. Matt Statman. He was supposed to, according to the email I received, see her this past Monday. We have not had an explanation as to why he didn't assessment on Monday. Ms. Henderson has informed me she had some contact with him Friday, but it's our understanding that all the businesses the government buildings are closed on Friday in observance of the holiday. So we are asking.
I think there's still, the jail doesn't close.
I'm not clear on if his department closes or not.
I think Mr. Statman is actually private, so he's not.
Okay.
So, if it's going to be Friday, he would be able to do that because he's not going to shut down on Friday and jail doesn't shut down. So.
Okay.
Okay.
I understand. So we were hoping that this would be scheduled for today's court date when she had an opportunity to revisit bond with you, Your Honor. I understand that there were some holds on her. She currently has a court date scheduled on the 7th for the MDOP case. And I understand that they're not issuing bonds, so she would still be held here through that Friday assessment and have to appear Monday morning from the jail. I'm representing her on that. She has one other hold. I was retained just in the past couple of days. I did not have an opportunity. I can't fax in my appearance to that court, but I will file an appearance today with that other court. So she has made a plan to take care of these.
Is that the other OWI?
So, Your Honor, I think there's two holds of importance. There's the OWI hold out of Clinton Township and then the MDOP that counsel is referring to. That's out of Shelby. I was able to call Clinton Township last week actually and spoke with them about whether or not they were going to pick the defendant up on that hold if she were to be released. They were unable to give me an answer. They said it was up to the command at that time. So I spoke to, they indicated that it's unlikely they were going to come pick her up on that misdemeanor OWI if she were to be released. I was not able to get a hold of Shelby Township to see what they would do if the defendant were to be released.
Okay.
So
Go ahead.
We are requesting that in consideration of this, she reduce her bond. She has been able to take a leave of absence from work. I think that the court is aware she's a single mother. She is the only one that pays her household bills, including her rent, her daughter's daycare. While she's in good communication with the child's father, she has an apartment she can lose. She has a job that's a very good job she can lose. It's my understanding that even with understanding that she has these issues with courthouses, that GM is very supportive and would also be able to provide some supportive care to her. They have programs, they run through this. My client's also willing to go in through the program through her work.
Right. And you weren't here, of course, counsel. I've heard all of that before, which is why what I was trying to do was fashion something that's an appropriate release for her. Because I'll be honest with you, when all of the factual circumstances of the other OWI. This one comes in and the prior one, and just the factual circumstances. I'm more concerned about her well-being, and that if I release her, that we're going to get her back and that she'll be alive. I mean, I'll just be blunt about it because of what she was doing and how she was sort of conducting her life. That wasn't going to be long before something tragic happened.
So,
and that's why the last time we were here, I think it was the last time or maybe the time before that, we were going through all of those other cases, the timing of all of them, what happened sort of, or at least alleged to have happened in this case, all of that. And why and what I indicated is I would consider her release, but I wasn't going to do so until I had an assessment to try to figure out where she was at, because I was also aware that she could take advantage of the employee assistance program and everything. I realized there were things out there, but.
I'm speaking about that as to additional support, Your Honor. So I know that sometimes people have a problem with not being able to be forthcoming with their employers. And I understand that while the court supplies a lot of different methods of support, I actually did explain to Ms. Henderson that part of the assessment is also getting her resources she needs and making sure that she is being addressed, her health is being addressed in the proper way. It is an additional supportive program that could be added. So that's my intention in bringing it forward for the bond argument that I'm making. In addition to anything the court would order, she has a program through work and she has a supportive program through work that has helped.
No, I don't, because she works for GM. I don't have, right?
Yes.
So I don't have any doubt about the employee assistance programs there.
Good.
That was not my issue. My issue was, where was she at? Like getting a full picture of her before I released her. Because I can tell you, and I'll just be blunt about it. My thoughts, her family comes in and they're here with her all the time. And if I had released her that day and said, get yourself into the employee assistance program at your work because it's a good program, I would not have any assurity that she would do that. I just didn't. I mean, it was sad for me when she came up here. You hear the facts of the case, and here's a young lady standing before me, and she's just a lost soul, as I viewed it. And a lot of that I don't think being her family's fault, her fault, nobody's fault. It's just my assessment of where she was.
I totally appreciate that you are taking into consideration, not just public safety, but the defendants before you and the impact it can have on them as well as the public and their lives. I very much appreciate that. I did want to make the court aware of something. I talked about her rent and her apartment. It's not really fair to say she's going to lose her apartment. We had to get a lot of information from my client. It is my understanding, it's her intention to let go of the apartment and move in with her mother. Is that correct, Ms. Henderson?
Yes.
Yeah, it's my understanding. She is dealing with the financial aspect of this. Obviously, she's well aware, Your Honor, of the impact it can have on other areas of her life, but she is determined that she's moving back with family once she is released. So I understand that the court would like.
The mom back there.
Yes.
Right there. Okay.
So I understand that you would like to have a clearer picture of my client before you fashion any type of a bond or any type of conditions. However, we would ask that if you're not going to lower the bond today, that you set a court date if she is having an assessment on Friday. I understand she will be held till Monday, that you set a court date very quickly next.
No, I don't have a problem setting a special date even to try to deal with it.
Okay.
But I need that assessment. And I mean, she can have the assessment on Friday, but I don't know if I'll have something that
I understand.
I can look at. And I think Ms. Henderson understands something probably about me that we had that whole day. I am not letting you out to die. Just not happening. And not until I'm sure. So if you want a quicker date, I don't have a problem doing that. But I don't know what I say that my staff is like cringing, but Friday. I know that. What's my next? I could move it up one more week. So instead of setting it for the 15th, I'd set it for the 8th to address her bond.
I do have to be someplace. I have to be in Southfield at 2:15 in person for an examination. Would we be able to do that early?
I'd set it early. Well,
or would I have?
No, our block on that date is at 10.
Correct.
Because she's in custody. So the block that she'd be in is at 10 o'clock.
Would I have permission to appear by Zoom on that day?
Fill out the form. We're not going to have a problem necessarily doing that.
Good. I would hate to be late to you or to the other court date.
I don't care about the other court date.
Yeah.
Just so we know. Okay, so I will adjourn this out, and I won't rule on your bond motion at this time, mate, but I'll adjourn it out to July 8th, 2026 at 9, or well, I set it at 9. She'll be in the 10 o'clock block. Let me tell you.
Thanks.
All right. Thank you. Is that her little one? Court does call the case, People versus Archie Minor.
Henry Solar on behalf of Eastfield Township. Hearing clerk for the people on the file ending in 1787.
Good morning, this is Defendant Laura McNally on behalf of Mr. Minor. I have had no conflict with Mr. Minor. I did discuss with him. I don't. You can just walk around. I don't have an explanation for the
Bench warrants will issue on both of the case. Bond will be set in the amount of $5,000, 10% privilege. Those will issue immediately. Court calls the case People versus Dorita Richards.
Morning, Your Honor. Hearing clerk for the people.
this is a short cause for.
Here we have.
Dorita Richards, not here. Bench warrant will issue bond 5,000, 10%. Court calls case People versus John Smith III.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Smith, who is now approaching. Mr. Smith, can you please state your name for the record?
John Smith III.
Your Honor, Mr. Cook and I are working on a resolution on this matter that may be contingent with what happens in his probable cause conference scheduled for next week. So I would just ask for a brief adjournment.
He's set for PCC on the.
He's set for PCC on the 9th.
9th. So if I give you the 15th, that'll work for you.
I hope so.
You're in the matter to July 15, 2026, 9 a.m. Bond. Court calls case People versus, I know what that's. Court calls case People versus Bellotta Cashman.
Morning, Your Honor. Raymond Cook for the people.
Morning. Yes. Morning, Your Honor. Sean Carroll, bring on behalf of Lada, and I have her here with me on Zoom.
All right. Your name? Yeah, no, she's right there.
Bellotta Cashman.
Thank you. All right, what are we doing? This is an arraignment, counsel?
That is correct, Your Honor. I would waive a formal reading of the arraignment. We, just this morning, I talked with the prosecutor's office, and for some reason, it wasn't until approximately 10:17 that they sent discovery. So I have not had a chance to review that with my client. So I'd ask the court to set a second pretrial in this matter.
And then having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned July 15th, 2026, 9 a.m. Mr. Bond, in this case, alleged BAC.
0.259. There was no crash, no known priors.
Counsel, anything you want to say regarding Bond?
Judge, I'd ask that the court impose a PR bond in this situation. She is currently attending AA 5 times a week. She's already been engaged with a therapist, and we're in the process of having her have an alcohol assessment.
Bond in this case will be set in the amount of $25,000 personal recognizance bond. All other standard conditions, including no assaultive behavior, possession of any weapons or firearms. There is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. There having been no previous priors, I will, however, order her to report within the next 24 hours to the Department of Community Corrections for placement on a sober link testing device.
Thank you, Your Honor.
Thank you. Court calls the case People versus Janina Williams.
Morning, Your Honor. People.
This is actually.
This is. No counsel. Hello.
Hello, Judge.
What's your name?
Janina Williams.
Okay, Miss Williams, you are before the court on a misdemeanor complaint that alleges that on or about September 18, 2025, at the location of 3825 Carpenter Road, that being the Meyer store, that you did commit the offense of retail fraud second degree. Do you understand the nature of that charge, ma'am?
I understand.
That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Yes?
Yes.
All right. My first question for you, ma'am, is do you want to be represented by an attorney?
The court trial, how to answer that.
Pardon?
I don't know how to answer that. I'm not sure.
Okay, well, do you want an attorney to help you through the process of this?
Yes.
Okay. You want an attorney or you want to do this yourself? You'd probably rather have an attorney, I think.
Okay. I'm saying whatever I can do to.
Pardon? I know, but here's what I'm going to do. Why don't this is going to become a public defender case.
My understanding, she just opens felony separate tomorrow where she's represented by the public defender. She's all ready.
Got it. Thank you, Mr. Cook. All right, this is a public defender case.
Assistant Public Defender Lauren Perry on behalf of Ms. Williams. Hi, Ms. Williams. We'll waive formal reading, stand mute to the charges, ask for another pretrial date.
She already had. But
That's what I'm asking for. Yeah.
She had a pen.
For the charges that I can find.
Yeah, she was actually arraigned back in.
That's from like 2010.
22nd of this year. All right.
So
already has a. I'm sorry. She has a bomb that I don't know how they added it, but. Yeah. Public defender was already.
Okay.
That's what it's not. I don't know what happened. All right, but we got it straight now.
Well, Your Honor, I'm just now speaking with Ms. Williams about her bonds on her other files. She thinks that she can bond out on her other cases. I did briefly look at X jail. I think most of them are set at like $100.
This one is set at $100.
Okay. I guess I'd ask for a PR if the court would consider that, just to give her $100 less.
But if she doesn't post, then she's not getting credit. I mean, I do that unless there's a strong objection from the people. I give her a PR.
So let me confirm that I once. They submitted 3 pending requests for this defendant to pursue conduct between February and May, or February this year. I'm going to do my best to get those reviewed as soon as possible, but it's likely there's going to be further retail for us coming down.
Thank you. So I'm going to leave her bond where it is. What do you want me to do with the case?
I just asked for another pretrial date, Your Honor.
Pretrial in this matter, July 2029.
Any chance to get a late pay just because she does have those pending warrant, and I want to make sure I can attend to get those sworn to next day just in case humors.
My next date after that is August 5th.
There should be enough time if defense is okay with that.
I think I'm okay with that. If something happens with her other bonds, I'll get in touch with Mr. Cook and Your Honors.
Okay, that's fair. So her bond will continue. I'll adjourn this to August 5th, 2026, 9 a.m.
Okay.
All right.
Don't do.
I'm going to come. I'll come explain everything. Okay.
Court calls case People versus United Cleveland.
We are reading for the people.
This is straight arraignment. Right.
Yes, I'm sorry.
Your name?
Anaya Cleveland.
Cleveland, you are before the court on a 2-count misdemeanor complaint that alleges that on or about April 14, 2026, at the location of 2220 Glencoe Hills Drive in Pittsfield Township, count 1 alleges that you did commit the offense of an assault and or assault and battery up on a Lucy Morris. You understand the nature of that charge. Count 2 alleges that on that same date and at that same location that you did commit an assault and battery upon a Sydney Collins. Do you understand the nature of that charge?
Yes.
It's indicated those are punishable by up to 93 days in jail, $500 fine plus court cost on each count. Do you understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
Public defender.
Yes, Your Honor. Assistant Public Defender Nicholas Vukovich on behalf of Ms. Cleveland. At this time, Your Honor, we will waive any additional formal reading of the complaint and be standing mute as to the charges.
Defendant, every way formal reading, standing mute. Court will enter a not guilty plea. You want it adjourned out?
Yes, Your Honor.
I'll adjourn her pretrial to July 15, 2026, 9 a.m. As to bond.
As to bond, Your Honor, at this time, I'll be requesting a personal reconnaissance bond.
Any response from the people?
No objection to appear bond, Your Honor. We'll be requesting no contact order with the 2 named victims, as well as a no go to 2140 Glencoe Hills Drive.
You say 2140?
Correct, 2140.
Okay. You live in Glencoe Hills, right? Okay. Set her bond at a $10,000 personal recognizance bond on under all standard conditions, including no assault behavior, possession of any weapons, firearms, and ammunition. There should be no possession of any alcohol, recreational marijuana, or any illegal drug. You understand that, ma'am?
Yes.
I'm going to order that there be no contact with Lucy Morris or Sydney Collins.
Okay.
Okay. I am also going to order that you do not go to 2140 Glencoe Hills Drive. All right. I'm not entirely clear on the proximity to your address, but it looks like they're in different parts just fine.
Yes.
All right. July 15th, 9 a.m.
Thank you, John. No, this is information being called before you. That's okay.
Court calls case People versus Paul Lip.
Morning, Your Honor, Raymond Cook for the people. Mr. Burgess's case, I know I saw him earlier today. I think he said he had
It just come in the door.
I can step out.
Okay, thank you. Yeah, I'll take some. I'll take some, but then I'll break at some point.
No, you're fine. That's the rest of
Right.
Sorry, Your Honor. Good morning. May it please the Court, David Burgess on behalf of Paul Ledford. Sir.
Paul Hayes, Life 4. Thank you.
Your Honor, we had, he has another pending felony matter that we had referred for competency a couple weeks ago at PCC.
Okay.
I think that there's a date in September, if I'm not mistaken, for that. I was just going to ask that, obviously it's the same issue, Judge.
When, October 7th. All right. Then I'll adjourn this matter out to October 7th, 2026, 9 a.m.
Do you need another order submitted with this case number or?
If you want him viewed on competency on this case, yes.
Well, I know. I was just trying not to be redundant, but I can submit another.
Well, and I would hate him sent for competency, even technically, on a disturbing the peace.
Right. I understand.
I'll just adjourn it out and we'll just follow along with that other comment.
Okay. I just didn't know if you wanted another order submitted. That's okay. That's what I was checking. Thank you, Your Honor.
Court calls case People versus Marcos.
Your Honor, Raymond Cook for the people.
Tenant Tilly.
This is an arraignment without counsel. I don't.
Don't have the defendant. Do we have the alleged BAC on this?
0.251 and there was a crash.
251. A crash. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. Cash surety. Court does call the case People versus Dean Thrush.
Your Honor, Raymond Cook for the people.
Arraignment without.
Dean Thrush. You don't have him.
I'm thinking maybe I'm on A. Oh. Yeah.
Dean Thrush. Not here. This issue in order to show cause on this one. Court calls case People versus Nekia Parker Webb. I said that all wrong.
Good morning, Your Honor. My name is PA8515 here for Nekia Parker Webb. Your Honor, I did speak with my client. She is on the way. She should be walking in the door about 5 minutes. Text me.
5 minutes?
Your Honor.
I gotta wait 5 minutes?
Your Honor,
where was she? Hold on a second. Oh, she's coming from Detroit.
Yeah, she did indicate to me that she had to find a babysitter last minute. Her first babysitter canceled on her. So we're just asking if you can recall the case.
I let people bring babies, right? Long as
Record should reflect I handed defense counsel a notice of intent to use of laboratory report.
okay.
If I could give that to Mr. Allen, we give that report. Thank you.
All right, I'll pass the matter.
Thank you, Your Honor.
Client. The child can come as long as they're not babies. I know. I shouldn't have said that out loud. What'd you say?
If you want mine.
Court calls the case, People versus Ryan Atkins.
Well, Conrad Solar on the
We have another something over for the volunteers in fact with Mr. Atkins. It looks like Mr. Atkins. Take your name, sir.
Up there he is.
Ryan Atkins.
Thank you. All right.
Yeah, I didn't have a chance to speak with Mr. Atkins prior to the hearing. I'm not sure if we don't have a good number for you, Mr. Atkins.
You do. My phone was broke. If you called last week, my phone was broke.
Okay. You want me to just put it on? All right.
The status,
All right.
I don't know.
Mr. Atkins, hold on.
Yes.
Your phone is your phone fixed now?
Yes, it is.
Okay, so let me do this. I'm going to adjourn it to July 15th, 2026, 9 a.m. That way you can get in touch with your attorney, figure out what you guys are going to do.
Sounds good. I appreciate it. Thank you.
Thank you. Take care. Court calls the case, People versus Fantasia Allen.
Conrad Solar on behalf of Township.
No relation.
And Assistant Public Defendant Nicholas Bukovich, I'm having Ms. Allen, who's appearing via Zoom.
Ms. Allen, state your name, please.
Fontanasia Allen.
Fontanasia.
I'll be asking for a slightly longer adjournment just to allow my client time to work on obtaining her license.
August 5th, 2026, 9 a.m. Bond continued. Thank you, Ms. Allen.
You're welcome.
Court calls case, People versus Quaternarian Andrews.
Conrad Solar on behalf of Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Andrews. Ms. Andrews, state your name for the record.
Hi.
Oh,
Hi, my name is Quinarian Andrews.
how do I say that first name?
Quinarian.
Quinarian? Okay. I'll never remember, but okay. Thank you. All right.
I have one question, Andrew. Ms. Anderson.
There you are.
In Detroit that she'd like to try to pay off.
She's trying to pay off tickets out of Detroit.
Yes.
All right. How much time do you think you need to get that done?
I don't know. I have a lot of tickets in Detroit and I haven't got down there.
I'm looking at your thing. You do. You have quite a bit.
Yes.
All right.
Yes.
Let's see. Let's see what we can do. What's August?
It's not specific.
Yeah. Okay, we'll go the 5th. I'm going to put it out to August 5th, 2026, 9 a.m. All right.
Okay, thank you. I appreciate you.
All right. Take care.
You too. Thank you.
Court calls case, People versus Johnny Barney.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Barney. Your Honor, I have not had contact with Mr. Barney, although I did try to get in touch with him. I have no explanation for this.
Bench warrant will issue bond 5,000, 10%. Warrants issue immediately. Court calls the case, People versus George Bowman.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Bowman. I did speak with Mr. Bowman. That might be him on the Zoom user.
Mr. Bowman. You think that's him?
Yes, me. Can you hear me?
Yeah. Are you Mr. Bowman? I can hear you. He's frozen. I think we lost him. He's frozen. I'll pass this because I don't know if this was him or not. Court calls case People versus Joshua Brooks.
Conrad Soda, on behalf of Pittsburgh Township.
Yes, sir. My phone is not active. I don't have to call him. He knew I was there, but he said.
Okay, hold on. Who are you?
I'm gonna wait. Shit, I'm gonna call up there.
Give me your name.
Yeah.
That was him, right?
That's right. He's a 67.
Yeah, but I now don't have a picture, but I think it was a re-sign in.
The signature's been dropping in and out.
Got it. All right, Joshua Brooks.
Assistant Public Defender Nicholas Buckovich on behalf of Mr. Brooks.
Not in Zoom.
I did speak to Mr. Brooks this past week about this pretrial day. I did expect him to be here. I know he was working on obtaining paperwork that I was supposed to provide over to the prosecutor, so I would be asking for the consideration of an adjournment.
Bench warrant, 5,000, 10%. I consider that. Look at him. Court calls case People versus Diamond Buyers.
Conrad Soda, on behalf of Township.
Good morning. This is Public Defender Lauren Henry on behalf of Ms. Byers.
He's not in Zoom, and I adjourned this out the last time in June, a month, because she was in the hospital.
I did speak with her this week. I didn't mention being in the hospital any longer. I know she had court cases up in her court surgery case. She was present there. I see one day. That nothing.
Okay, all right. I was just gonna let you go. Bench warrant will issue for defendant's failure to appear, bond 5,000, 10%. Her case. Nope. We'll get it. Okay, I'll take it. When I know, but just all confusing. Court calls the case People versus Elgardo Chavez.
Conrad Soda, on behalf of Pittsburgh Township.
Good morning. This is Public Defender Lauren Henry on behalf of Chavez.
Chavez? No response.
I know.
You're batting 1,000. Bench warrant will issue for defendant's failure to appear, bond 5,000, 10%. Warrant will issue immediately. Court recalls the case of the People versus Parker Webb.
Conrad Soda, on behalf of the Township.
Good morning again. For the record, Maya Davis, PA 8515 here for Nakaya Parker Webb.
Come on up. We've been waiting like hours for you.
Ms. Parker Webb, keep please state your full name for the record.
Nakaya Parker.
Thank you.
I apologize, Judge.
Your Honor, without getting into the facts of the case, I'd seen some issues that I'd like to challenge in regards to the stop. Your Honor, looking to file a motion to suppress, and we're just requesting a motion date.
How long will it take you to get that motion to suppress in?
Your Honor, if I can have it in 2 weeks.
I'll require that the motion be filed by July 13th. Response will be due by the 20th. Then I will set a hearing on that motion for July 20th. And then we'll have the motion on the motion hearing on July 27th,
Your Honor,
Monday.
is the court available that Tuesday by any chance? I'm in Wayne County.
Yeah, but not for this.
Okay.
I'm out, so I won't.
Can I have the next possible date?
Pardon?
Can I have the next possible date, Your Honor?
After that,
Yes, please.
when? Okay. So motion hearing August 5th, 2026, 3 p.m.
Thank you, Your Honor.
Thank you. Court calls case People versus Brandon Klein.
And so I'm getting this township.
Good morning, this is Middleton for the Lauren Committee on behalf of Mr. Klein.
Yes, ma'am. Brandon Klein.
Thank you.
Your Honor, I'm asking for adjournment. Mr. Klein is going to make an appointment as Secretary of State.
Yes, I had that tomorrow.
Okay. So the 15th will work?
Yes, sir.
Yes, please.
Turn that to July 15th, 2026, 9 a.m. Both matters. Thank you, sir.
Thank you, sir.
Continued. Court calls case People versus LaShawn Covington.
And so on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of state your name.
LaShawn Covington. Not here, bench warrant. Bond 5,000, give a 10% privilege, warrant will issue immediately. Court calls case People versus Diamond Ford.
And so on behalf of Pittsfield Township.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Ford, who should be appearing via Zoom.
She's there. Ms. Ford, can you state your name?
Diamond Ford.
Thank you.
So after speaking with Mr. Siller, my client will be willing to admit responsibility to double parking today, and it's my understanding that the driving while license suspended should be dismissed.
That's correct, Your Honor. So we'll get count double parking. If you accept that admission, move to this regional attorney.
Stay there. And Ms. Ford, do you admit responsibility to the fact that on or about May 10th, 2026, Michigan Avenue in Pittsfield Township, that you double parked a motor vehicle?
Yes.
All right. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can you get that paid?
I do know. Sorry.
Sorry. About like 2-3 weeks.
Ms. Ford is in between jobs right now. She's about to begin transitioning into a new appointment. So we believe about a month for Germany without her having enough time to go between her 2 jobs.
That's what she said. I heard her. I don't know why Bukovich had to step in. You did just fine, Ms. Ford. Young lady, if I give you till the end of August, can you get it paid?
Yes.
All right. Get it paid by August 31st, 2026. Thank you, ma'am.
Thank you.
Court calls case People versus Zane Franklin.
And so on behalf of Pittsfield Township.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Franklin. I did speak to my clients this week, Your Honor. I do not have any explanation for failure to appear today.
Bench warrant will issue for defendant's failure to appear on 5,000, 10%. Warrant will issue immediately. Court calls case People versus Levi Gardner.
And so on behalf of Pittsfield Township.
Morning, Assistant Public Defender Lauren Perry on behalf of Mr. Garland. Like he's here at his.
Yes.
Yeah.
Mr. Gardner, state your name, please, sir.
Levi Gardner.
Thank you.
I did not have contact with Mr. Gardner prior to today. I did ask one of the PD interns to go grab updated contact information from him. Might be there now. So.
It's ball, Your Honor.
Thank you, Barbara. So I guess I've asked for, so I can get in touch with Mr. Gardner and see what's going on.
So if I said no, what? Then,
I said, try to get about.
wow, we're gonna go like that, huh? Whoa. You know, she's off on that lead. She just, I know, Ron, but that's Ron, right? But she's out on leave, comes back. No question, she just fires it.
Judge, sleep deprived.
Is that what it is?
Sleep deprived.
Okay, I'm not gonna mess with you then. All right. We'll adjourn it out. 15th and work?
Yeah.
Okay. To the 15th. Mr. Gardner, did they get your updated information from you?
She's getting it right now.
Is she?
Yes.
Is she being nice to you?
Yes.
Okay, because if she wasn't, I got people I can send down.
Oh, okay.
All right.
That's good to know.
We'll adjourn it out to the 15th, Mr. Gardner. You have a good holiday, sir.
Okay, yes, sir. You too. Thank you.
Court calls the case, People versus Malcolm Hanks.
And
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Hanks, who I did see via Zoom earlier.
Oh. Hello, sir.
Hello,
State your name.
Hello? Malcolm Hanks.
Thank you.
Your Honor, I'd be requesting an adjournment in this matter, potentially to August. He has some tickets to pay off. He does believe he should be able to get them done towards the end of the summer.
He's also got a warrant out of 14-2 he needs to take care of.
14-2, I will work with him to get that information over to how the warrant recall when 14-2.
I'll adjourn the matter out to August 5th, 2026, 9 a.m.
Thank you for letting me know, Your Honor.
Yeah. Court calls the case, People versus Alicia Holston.
All right, so we're on again. Malchit.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Holston, who should be appearing via Zoom.
Hi, I'm Alicia Holston.
Okay, we got her. All right, thank you. What are we doing?
I submitted a plea form and advice of rights.
Oh, the
court yesterday.
The tabs were the other way. No, it's okay. It's all right. I will. Okay. Plea form indicates that she's going to be pleading to retail fraud 3rd degree as charged. There is a sentence agreement of HIDA prosecutor's consent required and is being given.
That's correct.
In this case.
Yes.
That's the court's full understanding. All right. Ma'am, can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name for me again.
Alicia Holston.
All right. You can put your hand down. Ma'am, it is this court's understanding you're going to plead to the charge of retail fraud under the Pittsfield Township Ordinance. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed or had signed on your behalf an advice of rights form. Is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up those rights, inclusive of the rights under paragraph 5, which are your trial rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
Okay. On the date of March 11, 2026, 7,000 East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan. What'd you do at the Walmart that makes you think that you're guilty?
I was skip scanning at the Walmart, and it was due to financial insecurity.
All right. So you went into Walmart, you picked up some items that they had offered for sale, took them to the register, and then skip scanned those items?
Yes, Your Honor.
And the store is open to the public?
Yeah. And the store was open to the public at the time, ma'am?
Yes, Your Honor.
And you didn't have anybody's permission to do that, did you?
No, Your Honor.
Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. And the court would not be bound by any sentence evaluation or recommendation. You understand that?
Can you explain that? I'm sorry.
Okay. If you commit misconduct as defined by the court rule, sort of as not abiding by bond conditions, committing new offenses and the like, okay?
Oh, yes. Yes, Your Honor.
Between time of now and the time of sentencing,
Yes,
you would
Your
not be permitted to withdraw your plea. Okay, you understand that?
Yes, Your Honor.
And also, the court would not be bound by any sentence evaluation or recommendation, meaning this one, they're looking to grant you HIDA. If you do that, I'm not bound to do anything like that. You understand that?
Yes, Your Honor.
Okay. You have any other questions on that part?
No, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty in this case. Defendant is referred to probation for a pre-sentence investigation and report and consideration of HIDA. Sentencing in this matter will be
July 22nd at 9 a.m.
July 22nd, 2026, 9 a.m. All right, ma'am, what I'm going to need you to do is hold on the line for a moment, okay? We're going to put you into a room with my probation intake, and that way we can start the sentencing process, okay?
Okay, thank you, Your Honor.
Thank you. Bond will continue.
Go ahead, Your Honor.
Court does call the case, People versus Michael Holston.
Conrad Siller on behalf of Township.
Good morning, Assistant Public Defender Lauren McNally on behalf of Mr. Holston. I have not had any contact with Mr. Holston.